interim order. Here the plaint was returned with an extension of interim order. And my lord, this is the order passed by the learned single judge.
So how do we extend the interim order?
That's because, my lord, the learned single judge has said that since you have to go back to the division bench, because in the order, the first order, there was no liberty given to approach the learned single judge for extending the interim order. This is, my lord, the order of the learned.
To be mentioned, to be mentioned tomorrow. Shoma নষ্ট করো না।
Great.
চলো।
Appellate side mentioning.
Item 4 in the appellate side, commercial.
Commercial.
Well, I was under the impression it will be called today, but the lordship have fixed one matter today.
We don't know, Mr. Sharma. Let us see.
Commercial C application in connection with first appeal.
Yes. If it is called on, we'll hear it.
Or
I'm appealing for the.
if it can.
May be taken up after the vacation.
Urgency, my lord. Advocate comes.
Mr. Sharma, if it is possible, we'll take it up. If not, urgency or no urgency, we cannot.
No, urgency is there.
Chalo, Daku.
No urgency.
No. Advocate commissioner is to take steps, my lord.
Original side matter, non-commercial, item number 1. Item number 1, my lord, I have considered, my lord, it is my mistake. That to be mentioned matter. I go out of the list. Item number 2.
We are the appellant, your lordship. Mr. Banerjee. Who's for the respondent? Mr.
For the respondent.
Yes.
Led by Mr. Sarvapriya Mukherjee.
Pass over. Chalo.
Lord, item number 3.
Led by somebody, so what can be done?
This is that,
We understand, swimming club. Then, who is leading you?
Mr. Sarvapriya Mukherjee of Mr. Abhraj.
So go, please send a word to him.
Item number 4.
Okay.
Yes. Other side? Pass over.
Taken time.
Item number 5 to 9.
Mr. Jointo Mitra is leading me in this matter. We were going to just file a terms of settlement, but your lordship.
What do we do? Tell us. Pass over. Pass over.
Item number 10. Number 11.
Yes.
Item number 12.
Lordship, I appear for the
That's 1 second.
Item number 13.
আরো ভিউ আছে আমার ভিউ তো আছে থ্যাংক ইউ
There may be two problems in this bench taking up these matters. We are checking.
Martial matters, Lordship.
yes marshal
Ojulokhi, yes.
that's marshal man আমি একা এসে সকাল থেকে বসতে
No, sure. All Gojulokhi matters have to be released. My lord is not inclined to take up.
my lord has appeared
Not appeared?
very difficult to go my lord back to
But what to do, Mr. We are not going to.
no have I said anything to them or my demeanor was anything
12 item, konta call রয়েছে 12 বল 12,
12, 13, 17, 18, 19, 20.
12, 13, 17, 18, 19, 20 একই order করবে. We are not inclined to take up this matter on the personal ground of one of us. Judge সাহেবের নাম দেবে. Stop. Paragraph, let the matter stand released from our list and placed before the Honorable the Chief Justice for appropriate direction.
It would have been my first, the second matter before Justice Ryman.
First was MSME, no?
First was it. No one can tell me that anyone has been stopped in this court from arguing. So we come, Miller, in a very leisured manner and we argue.
Our misfortune.
Sorry, I mean, when conscience says, even remotely, if I know somebody
Lordship,
in the array of parties,
Can
we appreciate Lordship.
practice.
Item number 14,
hey, 14 released from my our list. Dokkineshwar, no way. দেখো এবারে আমার নামটা দাও খালি.
14.
My lord, item number 14, my lord, I'm for one of the interveners, my lord.
We have released it just now from our list.
Grateful to your lordship.
Item number 15,
May please, your lordship.
No, this is my appeal, my lord.
Mutton Mohol.
Yeah,
Oh my God.
we are mutton suppliers, right after my heart. It's a
Yes.
short, quick matter, my lord, one way or the other.
Yes, other side.
There cannot be any other side because it's an embarrassing order which I have suffered. Clause 12 leave was not granted.
Yes, let us see the plaint.
Yes. Kindly take the plaint which commences at page 14
Mr.
onwards.
Mr. Ratnako Banerjee finds this very amusing because it was it your first matter? First matter, I was leading him.
Right.
And we will not name the learned judge, court to number 7. And, you know, I had put in 2.5, 3 years. So I was like a dada. So I said, you obtain the clause 12 leave, no problem, you know, just say which part of cause of action. He, after some hesitation, he said, no, I will not.
I said, no, I don't want to do it, please do it, please do it.
So I said, no problem, I'll take it. I'll obtain leave. So I made my submission with dictating a 2 pages order, refused.
Refused.
Clause 12.
Mr. Banerjee was
I was saying, but
Same.
I must, the sequel is 11:30, this happened. My lord dictated the appeal immediately, we moved at 2:30 and we got the clause 12.
Clause 12, interim order, everything we got. Let us see.
My lord, plaint is commencing at page 14. So far as the cause of action is
Stay
concerned,
petition, stay petition.
stay petition. Para 24 is, my lord, where we have pleaded within an outside jurisdiction. And para 7A and 7B, my lord, are the relevant paragraphs so far as the cause of action has arisen within jurisdiction at page 17. The money lent and advanced, partly performed within jurisdiction inasmuch as payment was received by the defendant within the jurisdiction. That is, my lord, my pleading so far as clause 12 leave is concerned.
So you lent money to the defendants,
Defendant number one, my lord.
defendant number one, and from your bank account,
Outside jurisdiction, the money went to the defendant's bank account within jurisdiction. So
Hmm.
performance has partly happened within the jurisdiction.
issue. This appeal is directed against an order dated
8th April 2025.
April 8, 2025, whereby, a learned single judge of this court declined to grant leave under clause 12 of the latest patent, 1865, to the appellant who proposed to file a suit after obtaining such leave. Stop. Paragraph. Stop. Hence this appeal. Paragraph. We have gone through the plaint. Stop. The short case of the appellant oblique plaintiff is that the appellant oblique plaintiff is that the plaintiff lent and advanced money to the defendant number one. Stop. Such money was transferred from the plaintiff's bank account outside the jurisdiction, outside the ordinary original jurisdiction of this court, to the bank account of the defendant number one within the ordinary original jurisdiction of the court. Stop. In our opinion, this would suffice for grant of leave under clause 12, since such transfer would constitute part of the plaintiff's cause of action. Stop. There are other pleadings in support of the prayer for clause 12 leave, which we do not deem necessary to address in view of the in view of our opinion recorded above. Our opinion recorded above. Paragraph. The order under appeal is set aside. Stop. Leave is granted to the appellant oblique plaintiff under clause 12 of the latest patent. That is all.
Grateful.
Appeal and application cat shop disposed of.
There was another leave which I had prayed for, and actually that was not considered. Order to rule 2.
No, that you will have to renew your prayer there.
Well,
Without clause 12, naturally.
Yes, absolutely. I bow down. Grateful.
Item number 16.
My appeal
Yes.
directed
Who's on the other side, Mr. Chakraborty?
we have served notice. In fact, Mr. Avinash Kankani is leading me in this matter.
Shall we pass it over once?
Item number 21 and 22.
21 and 22, my lord. In the other appeal, my lord, I am appealing for the Elma, that La Martiniere matter, where Mr. Jishnu Shah was addressing in the first appeal.
In the second call.
Pass over matter item number 2.
My appeal, your lordship.
Have you served?
Yes. They appeared on the last appeal.
Oh, I see.
This is the club matter, Mr.
Yes, Mr. Banerjee. Ratnakul
he's
Banerjee is leading you.
He's leading.
You're for the club.
Club, I think, everyone's together more or less. Mr. Abhijit Mitra is for the club. I am for one of the committee members.
Is this the matter which we were hearing, or this is a separate matter?
No, the same matter.
Same
Your
matter.
lordship have heard.
This particular application we were hearing, or this is
The particular application.
the you want to do it now, or you want to do it?
We are ready. We are ready.
Take some time, I'm sure.
No, Mr. Sharkar, please exercise your discretion. Today is the penultimate day. Now, if you think you will take about an hour, that won't be fair to the other matters.
I know. It will take some time.
If it can wait till after vacation, then we'll post it on the 9th of January itself, 9th of June itself.
Your Lordship, grateful it can be taken on instead of 9th, 10th or
Yes,
11th.
11th,
But if a time may be fixed, Your Lordship, that's the only request.
come back, we'll see. Normally, we call all the new
Lordship,
applications.
that we know.
Right. Today is the penultimate day before the summer vacation. Stop. Learned advocate for the appellant says that hearing of this matter will take some time. Stop. Paragraph. As suggested, list this matter once again on June 11, 2025.
Lordship,
Retaining its position.
Lordship, deeply.
Because we also have a problem in this because there is a provision that this has to be held within 3 months period.
So that Your Lordship has given that
Passed an order.
passed an order protecting them to that extent.
Yes.
Deeply.
Item number 3.
Item 3 and 4 are together, my lord. My lord, this is my suit, my lord, which was filed in the year 1992. My lord, the suit was dismissed, my lord, because there was an application, my lord, for rejection of plaint. Now, my lord, there were two applications. One was rejection of plaint, and the other application was for appointing a special officer and a receiver. So both the applications were dismissed, right?
Plaintiff's application and defendant's application.
Both having dismissed, my lord, two appeals were filed. GA, my lord, appeal APO 555 and APO 504. Now, my lord, in the appeal, my lord, a decree was passed. My lord, that decree, my lord, was on 22nd May 1997. The moment the decree was passed on 22nd May, 23rd May, my
Decreeing the suit.
decree in the appeal
The suit was allowed. The suit was allowed.
was allowed. My lord, now,
No further appeal.
further appeal was filed. My lord, all dismissed. My lord, then, my lord, it was, my lord, we had the next day applied, my lord, for drawing up of the decree. That decree, my lord, has still not been drawn up.
Oh.
Now, my lord, we have been kept on given, my lord, questions which we had to address. We, my lord, filed another application with this honorable court.
This matter twice.
Now, my lord, then my application, if my lord may
You see, there's a note from the master. This master is a new master. So she has asked for a little time to look into the matter and find out why the decree has not been drawn up and to do the needful for drawing up of the decree. So you can go through this note if you like. Eta dekha onake. So we'll place this 1 week after the vacation and we'll call for a report in the meantime from the master.
my lord, only one more submission. Whatever questions were raised in this application, if my lord would kindly once take my application, I have answered everything. Now, my lord, during vacations, my lord, if she wants any assistance, my lord, if she goes through this application, let this be considered, my lord, at the time of my lord going through the brief. Why, my lord, I state is, my lord, we kindly, my lord, once take my application, my lord, every question as to, my lord, the question number Well, may kindly see, my lord, from page number 13. Yeah, page number 14, my lord, paragraph 26.
Ms. Ghosh, what we were thinking, the decree has to be drawn up. Why keep this pending? We'll direct the master by the end of June
My lord.
to draw up the decree and dispose of the application.
Get even a master's notice, my lord. Why it cannot be? But I just stand corrected.
No, cannot be meaning what, Mr. Roy?
I just what happened, my lord. He said this did not order. This suit was filed on Devraj Chaudhary for declaration of a Mittal settlement as illegal. The argument that order 7 rule was allowed. Then there's appeal. In the appeal, there's some scope. This the nature of partition has been given, but the list of my lord properties are not given or still are not given there. Then my lord, Justice Division Bench passed the order. Then my lord, it went to the section 152. My lord, there also my lord.
Mr. Chaudhary, kindly see that note of the master.
152 application was not allowed. Then they went to Supreme Court. That was also disallowed. Then, my lord, after 15 years, they have come division bench. Division bench says you have to call it from the orders and the material. That my lord will say. And the master says from that orders and the documents, we can't call that the list of properties.
That unfortunate part is, my lord, the learned master is sitting in appeal over the division bench. Para 26, Lordship will find each query asked, my lord. We have given the answer, my lord. We have put it, the answer given by my learned advocate.
So therefore, Mr. Chaudhary, why do we keep it pending? We'll direct the master to do the needful and draw up the decree by the end of June.
My lord, kindly, my lord, after drawing up the decree, my lord, let it be here because, my lord, from 1997, my lord, I am being denied because
you
of, my
want
lord.
the application to be pending.
Yes, because, my lord, there was earlier an order of division.
We'll keep it pending.
Yes.
We'll keep it pending.
My lord,
Who are
otherwise,
you?
again, my lord, I fear, my lord, something will be done, some mischief will be done. My lord, I cannot say many things over here.
First, two sentences, Lordship, for
Yes.
but there is a decree.
Yes.
Who filed order 7 rule 11? Decree passed by the appeal.
Order 7, Rule 11. Ms. Ghosh said that was application was dismissed.
Application order 7 was dismissed. On the appeal court, the parties entered some sort of settlement which is called a Mittal settlement with a modification with some orders. So it was an order dated such and such will form part of the decree. So that was the decree passed by the appellate. Because one of the grounds is property. Actually good. So that happened. Thereafter, there was no schedule. So my learned friend files a review application or to include 151 for including a schedule. Because this contention is without that schedule, a degree can't be got. That's the contention. Those are all on record. I have produced. Against that, special leave petition. There again,
My lord, my learned friend missed one step. After, my lord, the division bench judgment presided by Justice Pal, the department pointed out there is no schedule. We said that it is there and we provided it. The department is putting a spanner at every step, notwithstanding two. And every time my learned friend is re-arguing on merits.
you will not allow me to speak.
This is the fourth time he is re-arguing on merits.
Two sentences, Lord.
Two sentences, that's what you said you will. You have said 20 already.
Very well. That is merged with the Supreme Court order. Supreme Court says he tried that there. That Supreme Court says, sorry, we can't.
Your Lordship, the subject was direct the master whether he can do it,
I
and
have
then you
the
also hear this matter. I am with my
এসো এসো ওই ফাইলটা যেটা দেখতে দিলাম দাও we have gone through the note of the learned master dated May 20, 2025. Stop. Paragraph. Let this matter stand adjourned and be listed again on July 2, 2025. Stop. In the meantime, learned master shall do the needful and ensure that the decree of a coordinate bench passed on
22nd May 1997.
May 22, 1997, is drawn up, stop. The parties shall extend full cooperation to the learned master, stop. Learned master will be at liberty to go through the present application filed by the appellant, by the appellant. Stop. হয়ে গেল, same order in both the
indicate why.
paragraph না হয়ে গেল না. On the adjourned date, the master shall file a report before us, hopefully along with a copy of the drawn up decree, stop. Otherwise, the report shall indicate why the decree has not been drawn up.
My lord, kindly also record that the queries raised by the erstwhile masters, my lord, the answers are there at para 26 of this
Paragraph.
application.
Mr. Chaudhuri, learned senior advocate appearing for the appellant oblique applicant, says that all the queries that were raised by the erstwhile master have been answered in paragraph 26 of the present application.
However, I have dealt with all the points taken by Mr. Chaudhary. This is my operation, my lord.
Paragraph Mr. Roy, learned senior counsel appearing for
That's not two, my lord.
the respondent number 2. You are also filing affidavit. And Mr. Ghosh, learned senior counsel appearing for the respondent number 3, file their respective clients' affidavit in opposition to the present application. Stop. Let such affidavits be kept with the records. Stop. Learned master will be at liberty to go through such affidavits. Also. What is that? Oof. Paragraph. Affidavit in reply filed on behalf of the appellant be also retained with the records.
How can you include a schedule?
My lord, these sort of points we will argue, my lord. It is, my lord, a very, my lord, grim picture of how, my lord, a decree is being thwarted because of some vested interest. I cannot say more than that.
He got everything. He has sold off everything. So he now wants a court stamp on that.
And every time, this is the third division bench we are doing.
He wants a stamp. Now
2nd July.
I'm not in this suit.
My lord, only one humble prayer, my lord, with the leave of my senior. Well, let it be kept in my lord's list, my lord. My lord, because we have been arguing this before different benches.
It is in our list.
My lord, as part heard.
No.
No objection.
Chalo.
Item number 5 to 9.
5 to 9. Settlement.
I appear for the respondent.
Yes.
I'm happy to say we have managed to settle. There were several disputes between the parties. Mr. Chaudhary is for the appellate. We have basically, my lord, I'll just tell your lordship in a gist. Fight between two brothers. We have entered into a family settlement overall.
Prakash was the father.
Om Prakash was the father.
Om Prakash.
And Subhash and Neeraj are the two sons.
Acha.
The original terms of settlement. What we have agreed on is in this memorandum of family settlement, everything. As far as the appeal is concerned, your lordship will see our terms that we are agreeable for the grant of probate to my learned friend's client. And the terms will be kept on record like mentioned in Caribbean's case.
But I understand yesterday there was a trust suit which was also withdrawn by us as part of the
So we will just take the terms on record and
Yes.
dispose of the appeal in accordance with the terms.
PLA, the probate application.
It has become a content, it's registered as a suit now, no?
Not registered as a suit, but my lord, we have made a separate affidavit that we are withdrawing our caveat.
I
So
see.
then it can be disposed.
Both disposed of.
And your lordship, only that is not there in the terms. Your lordship will say that I'll withdraw the caveat and give my consent and I can file it in the department.
Do that better.
And your lordship.
So are we disposing of the
Yes,
suit?
yes,
Yes, yes.
the appeal and the application.
Issue?
Probate appeal.
Learned advocates for the parties say that the parties have resolved all disputes between them. Stop. A terms of settlement has been signed by the parties and the respective advocates on record. Stop. Copy of terms of settlement filed in court be kept with the records. Paragraph. The appeal action the appeals and the connected applications.
The number 9 is someone else's appeal, they'll withdraw it.
Oh, 5 to 8. The appeals and the connected applications are disposed of in accordance with the terms of settlement. Stop. Paragraph. Mr. Ghosh, learned senior advocate appearing for Shubhash Maniyar, Maniyar, says that Shubhash will withdraw his objection to grant of.
Affidavit here, your lordship will say that he has withdrawn his caveat and giving consent to the probate.
Acha, Mr. Ghosh, that is senior advocate representing Shubhash Maniyar, now files an advocate affirmed by Shubhash. Affidavit affirmed by Shubhash. Did I say advocate affirmed by Shubhash? Affidavit affirmed by Shubhash, whereby he withdraws his caveat and the objection to grant of probate and consents to grant of probate in favor of
In favor of the appellant.
In PLA 327 of 2020.
in favor of Dhiraj.
In favor of
The
my lord.
executor is the
In favor of the executors of the concern. In favor of the executors
327.
of the concerned will in PLA
327 of 2021.
327 of 2021. Stop. In such view of the matter, PLA 327 of 2021 also stands disposed of, the same being treated as on day's list. As on day's list, and probate be granted. Shall we say that?
Yes.
Yes.
Be granted.
Last paragraph of the terms, my lord.
Oh, it's there.
Page 3.
Here we've said we've consented. Your lordship will grant the probate.
And probate be granted in favor of the executors of the said will.
And the terms of settlement be kept on record. Because
We have already kept it on record.
Because the probate is being granted, like in Caribbean's case, they said you can't settle a probate.
Right.
It has to be refused or allowed. So we are allowing the probate, but that terms will be kept on record.
Probate
If we
granted
violate-
with the terms attached. My lord, that is the language
it will
used.
form- it will form a
Probate be
will.
granted in favor of the executors of the concerned will, along with the terms of settlement being attachment thereto, which will form part of the probate. Which will form part of the probate.
That is one of the just judgment in Calcutta.
61 Calcutta.
61.
All right.
Item number 9 is
1 second. Caveat and consents to grant of probate of the. Take a check. So 5 to 8 done. 9.
Here for the appellant card, I have instructions to it.
Very good instruction. We appreciate it. Learned advocate for the appellant says that he has instructions to withdraw this appeal. Paragraph APOT such and such is dismissed as withdrawn along with the connected applications.
I have suggested at my cost, I shall take all of us to the Ganges, my lord.
I thought you were about to say to the Calcutta Swimming Club or Calcutta Club for lunch.
Ganga Kuti.
Ganga Kuti.
Item number 10.
I beg to appeal for the appellant. This is an application for restoration of an order dated 17th of April 2025, my lord. Yes, my lord.
Restoration of an order.
Restoration of the appeal, my lord. The matter was fixed on for hearing on 17th of April, my lord. Subsequently, when due to the non-appearance of the parties, my lord, the matter got dismissed for default, my lord.
Lordship, we have no objection, my lordship. Kindly fix any date for hearing
For
of
hearing
the
of
appeal,
the-
my lordship.
For hearing of the appeal. Tomorrow you will do it.
My lord,
You will have to do it. Only then we'll fix it tomorrow. Otherwise, we'll fix it yesterday. All right. Issue. This is an application for recall, for restoration of APO 5 2025, which was dismissed for default on April 17, 2025. Paragraph. Having heard learned counsel for the parties, we are satisfied with the explanation advanced for absence of learned advocate for the appellant on the day the matter was dismissed for default. Paragraph. Accordingly, the order dated April 17, 2025 is recalled. Stop. APO 5 of 2025 is restored to its original file and number. Restored to its original file and number. Paragraph. GA 1 of 2025 is disposed of. Paragraph. Let the appeal be listed for hearing fairly at the top of the hearing list immediately after the summer vacation.
One indulgence, my lord, the arguing counsel is coming from Delhi, my lord. If my lord, a date be fixed, my lord, then that will be convenient. My lord,
My lords, may I just say something? My lords, I'm appealing.
Led by Mr. Madan, my lord.
I have to come from Delhi, my lord. Lordships, may kindly give me a date.
When will it be convenient for you? Tell us.
Whenever it's convenient for your lordships, my lords, even in this month is fine.
This month.
This month is also fine, my lords.
This Monday.
বলো কবে দিতে পারবে? তুমি তো টাইম ফিক্স করছো এমনিতেও। ফাঁকা আছে? 9th June 12:30 PM be convenient?
Yes, my lords. Yes, my lords. 9th June.
That's the reopening day.
Yes, my lords.
Okay. Be listed on that ওইগুলো কেটে দাও কি সব বললাম immediately সব কেটে দাও. Be listed on June 9, 2025, marked 12:30 PM.
Obliged, highly obliged, my lords.
Yes, you have a senior.
Yes, lordship.
Who?
Mr. Meghojit Mukherjee, my lordship.
Mr. Meghojit, but you will argue. So spend the summer vacation preparing yourself.
Okay, lordship.
Highly obliged, my lords.
Item number 11.
May it please your lordship. My lord, this is an appeal from a decree by which my application for.
Have you served, Mr.
Yes, my lord, I have served. They did not appear before the trial court also.
Affidavit of service to them?
ডিগ্রিটা আছে এখানে মেমোরান্ডাম আছে দেখালেই হবে my application for grant of letters of admission was dismissed on the ground that I have not proved either execution or attestation.
You are the sole executrix.
I am the person who is entitled to under the will. Beneficiary.
So what did you apply for? Letters of administration?
Lord,
So we'll hear out the appeal. We'll have to hear out the appeal, Mr. Kaur.
Yes, my lord, but before that, your lordship will kindly see. If your lordship takes my application the orders that are annexed to the petition, my lord.
The impugned order.
Not the impugned order. The order accepting the will and having it exhibited. Will has been proved and it has been, that is what I would like to show to your lordship. My lord, if your lordship takes the petition.
Suparna Pal Chaudhuri is your sister.
Suparna Pal Chaudhuri?
You are related.
No.
You're not related.
No. Not related.
Nobody appeared for the defendants in the before the learned single judge.
Appeared up to a certain time. As soon as the will was tendered, they did not appear. It was exhibited.
Correct service.
Page 9, if your lordship takes.
Mr. Corp, this is a question of grant of probate or letters of administration.
Lordship.
A serious thing. Please ask your advocate on record to serve once more. Once more. Serve. If they don't come, we'll hear you out.
It is for
And it is better that hand service is effective personally, because this is not 24 Parganas. Somebody can go and just serve. Ishuto, we'll post.
I was only praying before lordship. If your lordship will kindly go through the three orders that has been passed by the trial court.
Yes, certainly we'll have to go through the orders. We'll have to go through the orders.
Prima facie, the will has been tendered.
Very well. When we hear out the appeal, we'll have to go through the orders. This appeal is directed against a judgment and decree dated April 3, 2025, whereby a learned judge of this court dismissed the appellant's application for grant of letters of administration
The motion will copy.
in respect of the concerned will. Now, in respect of what, she claims to be the last will and testament of late Girindro Kishore Pal Chaudhuri. Girindro,
Kishore.
you are related to Girindro?
No.
You are not even related to Girindro? Paragraph. Mr. Kaur, learned senior counsel appearing for the appellant, says that the respondents appeared before the learned single judge up to a point of time and not thereafter. Stop. Before us also we find that although service has been effected, as would appear from the affidavit of service filed in court today, nobody appears for the respondents. Stop. However, we are of the view that another chance should be given to the respondents. Stop. Paragraph. Learned advocate on record for the appellant is requested to effect fresh service on the respondents and file fresh affidavit of service on the next date. Paragraph 11 June. List the matter.
My notice of motion है copy नहीं.
Item 21 and 22.
एगुलो दिन तो judgment गुलो दिन तो.
Item?
Judgment है copy दी चाहिए.
I did 21, 22.
I'm appearing to the appellant. I'm reading 21. But I'm praying.
नहीं.
21,
Talk to them. Talk to your other side.
20 item appellant item number 20.
Yes. He is suggesting after vacation.
Because Mr. Shah was making his submission.
Right.
Well, I can start, but I think Mullah didn't want Mullah just because
In which part of the world is he in now?
He's in Kolkata.
He's in Kolkata.
I also asked Mullah, I didn't know Mullah.
When? Give us a date. Give us a date.
Except 10th, my lord, any day, 11th, 12th.
9th, you are coming to court.
Yes.
9th will be hopefully a light day. So that's
I'm
what
good.
happens.
I'm-
9th
I'm-
June?
I'm-
9th করে দাও?
Right.
Huh?
ওই একই একই পরপর হবে তো। 9th is the month.
Very well.
So how does it matter?
How does it matter?
I don't know. Monthly matters will also be taken up. Mr. Sharma Malad has very different insights sometimes, Malad, which Malad is very difficult to.
Mr. Medora this morning moved a matter where the appellant was Mutton Mahal. Mutton Mahal, yes. We found it
But he
rather
got his
amusing.
plus 12.
He got it plus 12.
I went away, Malad.
This is for your information.
It took only 5 minutes.
Grateful. 9th.
Item number 16.
Item 16, Your Lordship, I am for the respondent.
This is my appeal. May I file my affidavit of service, my lord?
Yes. Item 16.
I have filed only, Your Lordship, the memorandum of appeal, so there is no scope for any interim order.
Who call for it?
There's no scope for any interim order, my lord.
Very well. No scope for interim order.
But
There
my lord,
any merit in the matter?
my lord, I will.
You're the plaintiff.
I'm for the plaintiff, my lord.
Hear out the appeal, Mr. Sengupta. All papers are before us?
No, my lord.
No.
I'll file the paper book, informal paper book.
This issue. If this appeal is directed against a judgment and order dated March 6, 2025, whereby the appellant's application for judgment upon admission filed in an eviction suit, being GA number 4 of 2021, was dismissed by a learned judge of this court. Paragraph, Mr. Kankani, learned advocate appearing for কে কখন senior হয়ে যায়? Let us see your gown.
My lord.
Gown. He senior?
No, no.
No, that's it. Advocate appearing for the appellant oblique plaintiff fairly says that there is no scope for passing any interim order. Stop. The appeal should be heard out. Stop. Paragraph. Let a requisite number of informal paper books be filed by the appellant, incorporating all papers that were available before the learned single judge. Stop. All formalities are dispensed with. Stop. How many defendant? One.
Three.
You represent all of them? Only one.
Yes.
Very well. Since all the respondents are represented through learned counsel, represented through learned counsel. Since all the respondents are represented through learned counsel, notice of appeal is deemed to be waived. Paragraph, list the matter.
Two weeks time after reopening, my lord.
Very well,
File it.
list the matter. আচ্ছা ওইটা তুমি যেখানে বললাম না requisite number of paper books be filed such and such be filed by the appellant incorporating all papers that were available before the learned single judge, within 2 weeks after the summer vacation, bracketed date দিয়ে দাও 20 June 23. ওখানে দিয়ে দাও তবে ফিরে চলে এসো এসে last list the matter on June 25 under the appropriate heading. Paragraph GA.
There's no GA.
There is no GA. ঠিক আছে ঠিক আছে
Item number 23.
23 to 23. Mr. Daruju Dattu is not appearing. National Insurance.
Sorry, my lord. Yes, I'm for the appellant. Extremely sorry. My lord, this is my appeal.
Already gone on holiday.
Lord, this is my appeal.
Yes.
This is from an appeal from the decree number 25. Yes. My lord, item number 25 বোধহয় আমাদের NICL
25. 25.
দরজা 23 ডাকলেন তখন আমাদের 25 দর্শক বললেন 23
Yes.
My lord, actually NICL is item 25.
ওটা নয়. Oh, I see. All right. We withdraw whatever we said.
So should we also withdraw or your lordship will take it up?
23 then 23 কে কেউ নেই?
I am for the respondent.
Respondent pass over করো কেউ নেই তো.
24.
I'm one of the plaintiff respondent. No rent occupational charges have been paid for the last 3 months. There was a stay on the ground that they will be paying occupational charges as a precondition. Last 3 months, no. There's a decree for eviction which has been passed against.
এই order to দেখো, huh? Then stay is gone, has gone automatically.
My lord, kindly because
We'll let us see the order.
My lord, there is one of the issues is, my lord, whether it will be a commercial dispute or it will be a.
Whatever the issue is, sir, you have obtained a stay order on condition.
My lord.
Now you are not
Paying, my lord.
no last 3 months specific instruction, no occupational charges paid.
My lord, may I come back then, my lord, tomorrow?
When will you come back?
Because I have an instruction because we are paying.
If you are paying, then you are enjoying the stay.
My
If
lord,
you are
in
not
that case, may I
paying,
come back with the account.
let us
my
see
lord?
the order once. The wording ta erom thakle.
Well, the order,
Automatically
the order is of 28th of August 2023.
28th of August.
Well, it says that I'll be at liberty to execute the decree upon obtaining leave from the court. Well, then I'll be requiring mother the leave to proceed with execution. Internal page 2 of the order, my lord. Third paragraph from the bottom.
My lord, I have an instruction, but we are paying, my lord. In that case, my lord, may I come back with the account, my lord, tomorrow?
It's clear in default of payment.
Yes, but my lord, it also adds like upon obtaining leave from court. I can execute, but upon obtaining leave.
ওইটুকু clear করে
My lord, may I come back, my lord, because I have an
You come
instruction,
back,
my lord.
sir. All we will say, if you are paying, you'll be enjoying the stay. If you are not paying, they'll be at liberty to execute. That's all we are saying. Esho? The appellant had obtained an order of stay of operation of the decree that it suffered before the learned single judge on certain conditions. Stop. One of the conditions was that on and from March 2023, the appellant shall pay occupational charge to the respondents at the rate of rupees 1,00,000,000 মানে 1 lakh per month. Stop. From August 1, 2018 till February 17, 2023, which was the date of the decree, the appellant shall pay to the respondents occupation charge at the rate of rupees 38,000 per month. Stop. All such payments will be without prejudice to the rights and contentions of the parties. Paragraph. The relevant portion of the order, paragraph. The order dated August 28, 2023, whereby stay was granted on the aforesaid conditions, also observes that, in default of payment of the occupation charges by the appellant, the respondents will be at liberty to execute the decree upon obtaining leave from the court. Stop. Unquote. Paragraph. Learned advocate for the respondents says that for the last 3 months, occupational charge has not been paid by the appellant. Stop. This is disputed by learned advocate for the appellant, who says that according to his instruction, occupational charge is being paid every month. Stop. Paragraph. We only clarify that if there is any default in payment of occupational charge, the respondents will be at liberty to execute the concerned decree. Paragraph. List the appeal immediately after the summer vacation. List the appeal for hearing. Paper books ready?
Yes, paper books.
Immediately after the summer vacation.
Grateful, my lord. Deeply obliged.
Item 25. My lord, point involved here is very short, my lord. This appeal is from the judgment or decree, my lord, which has been passed fixing the mean profits in terms of the special officer's report. My lord, may I narrate the history of this litigation, my lord, very briefly. My lord, National Insurance was a monthly tenant in respect of 19 RN Mukherjee Road for years. The first, the area occupied was 7,500 square feet in the ground floor and an additional area of 88 square feet for as a generator room. My lord, the first suit for eviction was filed by Hanuman Estates in 1998. That was before the City Civil Court. That was compromised on the basis of a solemnama on which the terms and conditions of occupancy were, my lord, written down, the rate of rent, etc. And after the period, my lord, expired, as was fixed in the solemnama, my lord, they filed the second suit, the instant suit, for eviction of the appellant. My lord, we suffered a eviction decree in terms of a Chapter 13A application by order passed by my lord Justice Shoman Sen on 7th May 2015. Appeal was filed. Appeal was also dismissed, and during the pendency of the appeal, my lord, an order was passed that you pay 1,80,000 as occupancy charges. We have paid that. Before the appeal court, my lord, we had given an undertaking that would vacate the premises. On 31st of January 2021, we have complied, we have vacated the premises. Now, my lord, after this appeal was disposed of, an application was made by Hanuman Estates for fixing the mean profits, and a special officer was appointed for fixation of mean profits.
Application was made before the division bench or
before the single bench? Single bench. Before my lord Justice Devanshu Poshak, and on 27th February 2020, Mr. Rajratna Sen was appointed the special officer.
Rajratna Sen.
Yes, for deciding the mean profits. My lord, special referee filed his report on 20th of April 2021. 20th April. My lord, pursuant to the filing of the report, my lord, the plaintiff took out an application
For
for
confirmation.
For confirmation. And we took out an
Exception
application
for setting
for
aside.
exception. My lord, after hearing, my lord, our exception was dismissed and their application was allowed and decree was passed in terms of the special officer's
Since
report.
that you have come up.
Yes. The only point involved, my lord, is that before the special referee, the valuer had placed his report and has fixed the rent at rupees 99 per square feet.
Valuer engaged by whom?
By the
you
plaintiff.
or-
By the plaintiff.
Plaintiff.
He was cross-examined, and another witness, Mr. Anirudh Jalan, the director of the plaintiff, was also examined, cross-examined. My lord,
Paper book আছে? আছে, ঠিক আছে.
it's a very narrow compass, my lord. Before the special referee, my lord, we took 3 points that when you decide the mean profits of a building, we have to take into account the location, condition, as also the facilities offered. My lord, the special officer agreed with us regarding the location and the condition. And he had reduced the rate of mean profits by 10 rupees per square feet. It became 89 rupees per square feet.
Valuer had said 99.
99. From 99, it became 89.
Just out of context, is there a reported decision in Dalhousie Properties Limited regarding fixation of mean profits? Does it come back to you instantly? No. Doesn't
my
matter.
lord.
Forget. All right. Yes. 89.
So now, my lord, my contention is that if you take the facilities offered when you compare two premises, the nearest premises, my lord, which was found to be suitable was 1 RN Mukherjee Road. It was a registered deed, and area was more or less similar. It was on the ground floor, same locality.
You are prepared, Mr.
I'm led by Mr. Sabyasachi Chaudhary, ma'am.
And now, don't ask for time after 15 minutes. Yes.
So my submission would be that if you compare the facilities that were offered to us, there were no car parking facilities, number one. And the registered lead, which was taken as the benchmark while fixing the main profits, there, my lord, many additional facilities were there. Like there was a facility for a VSAT on the roof, an ATM, a power load connection of 70 kVA, separate water meter in their own name, installation of a generator free of cost. All these additional facilities were there. So in our case, there was not even a car parking facility. So when you are comparing two buildings almost in the same locality, if you take the facilities into account, some more discount.
Scope for interference. Stop piece of it absurd na hobe. 88 rupees RN Mukherjee Road, 89. Absolutely all right. Yes.
So if you compare the facilities of these two buildings, some more discount has to be given.
According to you, how much should it be?
Fairly, my lord, rupees 70 per square feet.
70.
70 per square. Should not be less than that, but should not be more also. It is my submission. Your lordship.
You are submitting on instruction.
My lord, it's a public sector company, so
Yes.
lordship knows. Nobody takes any responsibility.
Do you think there is a scope for mediation on this point to arrive at a figure?
No, because my lord, Justice Ravi Kapoor tried his best, my lord, to settle this matter. He called the officers of my client in court, and the refrain was, if they agree to anything, there will be vigilance against them. So nobody wants to take any responsibility. You pass an order, they'll comply. That is the whole problem. I have told them also, accept. In fact, Justice Kapoor was nice enough to say that compel them to accept 70 rupees per square feet, but provided you undertake that you will pay. But I cannot make that undertaking. And the officers won't take any responsibility. So if there is an order passed by the court, they'll comply. But
very well, argue. So we fully appreciate. We have also appeared for public sector undertakings, so we know.
so this is, my lord, the short point that is involved. And before the special referee, my lord, we also argued the point of condition. And there was an earlier talk of settlement going on between Mr. Anuj Jalan and NICL, and 2 meetings were held. Minutes were drawn up where Mr. Anuj Jalan had accepted that there were problems like waterlogging, leakage of the toilet taps, paint peeling off, electrical problems, and he had recorded, my lord, that if the terms were accepted by NICL, then he would address all those problems. Unfortunately, my lord, here also NICL retracted. So on the basis of these 2 minutes, my lord, Exhibit R and Exhibit S, my lord, the learned special referee, my lord, had accepted that yes, the conditions were not very suitable and had made that discount. That area is, my lord, prone to waterlogging, and there were continuous leakages from the toilet. So he accepted the condition, but these facilities he has overlooked, and the transport has also overlooked. And my lord, the funny thing is, one judgment was cited by Mr. Chaudhary before the learned special referee. That judgment refers to that facilities should be taken into account. So it was there before the special referee. এটা দাও special referee status, volume 2. My contention is, my lord, that your lordship has to take into account, my lord, the facilities. Now, whether it would be 70 rupees per square feet or 75 or 80 rupees, that is, my lord, entirely up to your lordship. But something has to be done regarding the facilities. 30. এটা কি রে? এটা আমাদের অ্যাপ্লিকেশনটা। হ্যাঁ, আপনি এটাতে চেঞ্জ করুন। ও আচ্ছা আচ্ছা আচ্ছা। If your lordship takes up, my lord, volume 2, these points were raised in the...
Sir, one thing only. They submitted before the learned single judge in course of argument that the rate should not be more than rupees 65 to rupees 70. So they can't now retract from that. We will not allow them. Is your client agreeable to accept 70 rupees? Otherwise, what will happen? They will not stop here. They will go up to the Supreme Court. And nobody knows when the proceedings will finally be decided. You better take instruction.
On this, I will have to take instructions.
Yes. Issue. Let us record an order. Let them take instruction and come back immediately after the vacation. This appeal is directed against a judgment and order dated December 20, 2022, passed by a learned judge of this court, disposing of GA 5 of 2021 and GA 6 of 2021. Paragraph
79.
The appellant was a tenant under the respondent. Stop. The respondent filed an eviction suit to recover vacant possession from the appellant. Stop. The suit was decreed Stop. The appellant carried the matter to a division bench of this court. Stop. The appeal was dismissed. Stop. Paragraph. Thereafter, comma, the respondent oblique plaintiff filed an application before the learned single judge for appointment of a special referee for determining the quantum of mean profits that is payable to the plaintiff. Stop. The special referee filed a report before the learned single judge after considering the materials produced by the parties before him and the evidence adduced before him. Stop. The special referee determined the rate of mean profits at ₹89 per square feet. Stop. Paragraph. Square feet. Stop. Paragraph. The plaintiff filed an application, which was their application, GA5.
GA5 is their application.
Being GA5 of 2021 for passing a decree in terms of the special officer's report. Stop. The appellant herein filed an application being GA6 of 2021 for setting aside the report of the special officer. Paragraph. Paragraph no, by the impugned judgment and order, comma, the appellant's application was dismissed and the plaintiff's application was allowed. Stop. Hence this appeal. Stop. Paragraph. We notice from the impugned judgment and order that a submission was made before the learned single judge on behalf of the defendant oblique appellant that rate of rent with respect to the suit property ought not to exceed ₹65 to ₹70 per square feet. Stop. We inquired from learned advocate appearing for the respondent oblique plaintiff as to whether the respondent would be agreeable to accept mean profits at ₹70 per square feet. The learned advocate seeks time to obtain instructions. Paragraph. List this matter once again. 10 June, June 10. Under the same heading, comma, retaining its position.
Would your lordship be pleased to fix the time, my lord? Only because it was a short matter.
Consider. This will put an end to it finally.
Grateful, madam.
Item number 26.
26.
And for the respondent.
Yes.
For the appellant.
Lord, after they file the supplementary paper, I find that, my lord, there is incompleteness of the paper book because of the fact, my lord, Exhibit A, which contains the scratched signature of the testator. That page has not been provided with the certified copy. That is the backside cover page. My lord, I have brought that book, page number 11. Lordship will find, my lord, that is the reason why, my lord, we have given them letter. They practically agreed, yes, that is not, has not been possibly provided.
So now what, Mr. Chakraborty, tell us what?
I want that the court records, particularly containing Exhibit A, should be produced before your lordships.
My lord,
This is an appeal from decree passed by.
Appeal from, my lord, the dismissal of the application for grant of probate.
By which court?
But by the single judge?
Of this court.
Of this
Yes,
court.
You want the records of the suit. It was a contentious cause.
Contentious cause, and my lord, I contested, and my lord.
Very well, the records
My,
will be
my
produced.
lord, this is his original certified copy we have received. Nothing we
That
can
is
do
all
on
right,
that.
that is
That's
the
all
reason.
right, sir. What he says, he wants to consult the records of the suit. We'll call for the records.
My lord.
My lord, they have agreed. Is it your
We-
lordship's pleasure to see the letters of the
So
exchange?
if they've agreed. We'll produce the records. Immediately after the vacation?
My lord, there is a small indulgence I seek from him, my lord. Mr. Probal Mukherjee is leading this case for the appellant, and he is right now in London. He will be returning post second week of June. So more than a week accommodation for briefing up the case again to him, if it is on the third week or fourth week of June.
Why are you seeking something on his behalf? He has not taken you to London.
I mean, he's out of India right now, my lord. That is what I.
He has taken nobody. He's gone alone. Anyway.
I appreciate.
Which date you want? Tell us.
Post 25th, my lord.
26th.
26th or 27th?
27th.
The consent of my
27th.
Only, my lord, only I pray. I beseech before your lordship, Lord, if it is on 26 or 27, my lord, can it be, my lord, is a time?
No, Mr. Chakraborty, not possible. They show. Not possible. At least let us start hearing the matter, then we'll see.
My lord, my lord.
This appeal is directed against a judgment and decree whereby the appellant's suit, appellant's application for grant of probate, এটা কত নম্বর হচ্ছে 26 26 grant of probate of what the appellant claims to be the last will and testament of late Akhilesh Kumar Sinha, comma, which was registered as
Exhibit 1.
Not registered as Exhibit A.
the proceeding PLA was after becoming a contentious cause. It was registered as a suit. TS number?
TS number, my lord,
TS number
6th of 2009.
6th of 2009. Upon becoming a contentious cause, comma, was dismissed.
Dismissed by order dated 18th May 2020.
Was dismissed.
By order dated 18th May 2020.
Paragraph. As requested by learned advocate for the respondent, comma, let the records of the suit be produced before us on the adjourned date. Kaushik. Aninu. Stop. Paragraph. On the request made on behalf of the appellant, comma, let this matter be listed again on June 27.
26, my lord.
He'll be back on 25th, Mr. Mukherjee. He'll be jet lagged.
He did not say back on 25th.
No. Third
He
week.
says that he will be returning by third week.
By
He
third
will be
week.
making the preparation.
Some accommodation for
26th?
briefing up and that will be required. Some accommodation for briefing up will be required, my lord.
26 is
For waking up.
Briefing up.
Briefing. 30, June 30. 27, you are in difficulty.
No, my lord.
Then
I'm not in difficulty. 26, 27.
27, 27.
Grateful.
27.
I'm extremely.
Item 27.
Order, I appear on behalf of the appellant.
Yes, Mr. Bose.
This is an appeal from a decree. I had filed an originating summons suit requiring the Honorable Court, my lord, to give its opinion on a particular clause of a trust deed. I said, my lord, the deed is hit by the rule of perpetuity, which makes it a void deed. It is not alienable, and therefore
Devotur, no. Not
Private
Devotur.
private trust.
Private trust.
Now, my lord, it was heard in great detail, and interestingly, there are two suits filed by the respondent. In one, they support the trust, and in the other, they do not support the trust. But those are incidental factors which will come in. What was required of this honorable court was to give its opinion on that particular trust deed and a particular clause therein. Well, it'll take a little time.
tell us, is chapter 30 was within the scope of chapter 13
Yes, yes.
of the original side rule.
But the learned judge, without giving any opinion, has been pleased to say these are factors which will have to be decided in a suit. Whereas just the opinion was sought for.
When do you want it? Tell us.
Just 1 week after the vacation.
1 week after?
Because it's, in a way, it's virgin territory, the subject matter.
The
So we
appellant,
had a lot of cases to cite.
the appellant's originating summons suit was dismissed by the judgment and order impugned in this appeal. Stop. We are told that stop. Paragraph. Mr. Bose, learned senior counsel representing the appellant says that hearing of this matter will take some time. Stop. Today being the penultimate day before the summer vacation, Mr. Bose suggests that this matter be listed 1 week after the summer vacation. Paragraph. Mr. Ghosh, learned senior counsel appearing for the respondents, does not object to the suggestion made by Mr. Bose. Paragraph. List this matter once again on June 16, 2025, retaining its position.
Very grateful to my grateful.
Item number 28.
Lordship, I'm appearing for the appellant. Lordship, kindly keep the matter after the vacation.
After vacation. On the request made by learned advocate for the appellant, let this matter stand adjourned and be listed immediately after the summer vacation.
Lordship.
Personal matter, item number 23.
কেউ ছিল না এই তুই জানো কি respondent, give your appearance.
Yes, my lord.
23.
Yes, yes.
What is?
For the appellant, my lord. My lord, regarding this.
National insurance.
Yes. My lord, regarding this appeal is for the claim and it must be appeared in the commercial list. The appearing is a non-commercial list.
But there is another appeal which is there in the commercial.
Commercial list.
Should also come under
They should also come.
Yes, yes, yes.
করে দাও তাহলে।
And the matter tacked together and appear after vacation because today is Thursday.
Very well. Both their appeal.
Yes, yes.
Very well. After the puja vacation.
After the summer vacation.
Summer vacation. All right. করে দিও।
Item number 29.
Well, we were to come back with regard to the calculation of mean profits and what is agreeable to both sides. Now, this is the award by the special referee where the special referee has awarded a certain sum.
We heard this matter before.
Yes.
But you would recall Mr. Jishnu Chaudhary was there on the last day. But the special referee has awarded. The special referee awarded mean profit at 51 rupee per square feet.
You are plaintiff.
I am for the defendant, my lord. Possession, it's only a question of mean profit. Our valuer at, it is 43 rupees and 51 rupees. It fell from your lordship.
Oh.
Mr. Chaudhary said he is willing to come down to 47. But I have been able to persuade my client at 46 rupees per square feet.
Then there is no meeting point. For 1 rupee, you will carry on with this.
That I leave it to your lordship. And I'll tell your lordship where the issue is. My lord, kindly have a look at the chart. My lord, what I understand is we had forwarded them the chart. The issue is, my lord, we have calculated interest at 6%, my lord, on the reducing principal till we make payment. But the plaintiff now wants interest, my lord, right from the date, my lord, day one.
We were hoping, we've also made a calculation, my lord.
But that, my lord, my client will not be able to, then, my lord, we'll have to fix it.
We have added the interest of the period of mean profit calculation from 2014 to 17 and from the period of installment payment, whenever they start. There is no agreement.
Mr. Chaudhary says his client will not agree. Then we'll have to hear it out.
Malad kindly keeps it after the vacation. We'll take instruction because I'm led by Mr. Chaudhary. He's not here today.
46 rupees, he is agreeable.
We have also agreed to 46 rupees. It's
Oh.
just the interest which is at variance.
See, sit again. Sit again.
Yeah.
Royal China is a good place in Forum. Very good food, we are told.
Yes.
You can sit there together, both the
They
parties.
will not sit with me. I am a vegetarian.
Chalo, Esho. Mr. Chaudhary, learned senior advocate representing in this proceeding, you are the respondent. Respondent says that the respondent has now agreed to pay mean profits at the rate of rupees 46 per square feet. Stop. Paragraph. Which surname do you use now?
Hormone Rai.
Bormun Rai. Ms. Bormun Rai, learned advocate representing the appellant, says that her client is also agreeable to accept mean profits at the rate of rupees 46 per square feet. Paragraph. However, there appears to be a difference of opinion between the parties as regards the rate of interest and the period for which interest.
Rate is agreeable.
Rate to, he
6%.
says 6%. Is that agreeable? Oh, as a difference of opinion as regards the period for which interest should be payable. Paragraph on the suggestion of Ms. Bormun Rai, let this matter be listed again on
After reopening.
9th, 10th, 11th, 12th, 13th.
11th.
June 11, 2025, retaining its position.
Grateful.
You take this back. These are of no use to us.
Only one thing Lordship has recorded, we are agreeable to 46 without prejudice. In case, my lord, only just put that. Otherwise, my lord.
Says that without, Mr. Chaudhary, senior representing the respondent, says that without prejudice to its rights and contentions, the respondent has. We'll come back. Daku.
Item number 30.
I am there. Kindly pass it.
Pass it.
It was hard by your lord.
Oh, was it?
This Order 9, Rule 13, my lord, second proviso.
Okay. Yes. Yes. Having knowledge otherwise.
Since I have been, my lord,
Reply to the section 21
prevented,
notice.
my lord, from making a prayer. I am not making that prayer. Kindly pass it over.
You? You're appearing for your senior. Who's appearing for the respondent?
For the respondent.
All right. Pass over.
Item number 31.
Is that bank suit, suit against the bank filed by my client, the sale of property. We are challenging not the sale, but the creation.
Oh, that conveyance from D2 to D6 or something like that.
D6 to D2. Lordship.
D6 to D2.
Initially, my lord, I had placed the prayers in the suit, in the plaint, where we said that those prayers may not be granted by a suit court. And the other query which fell from your lordships was whether I had mutated the property and I had paid the tax. Lordship, I had mutated the property in my name in 2011 itself, just after it was sold, and I have up to date cleared all the tax. Initially, I had cleared whatever was due, and now subsequently, time to time, whenever bills are being raised by the corporation, it is being cleared. Those documents are also there.
Yes, but you said you will produce the sale
Deeds are also there. We have given a copy.
Given a copy.
Because it was a...
All these yes, the KBT SC Lordship can keep this on record and fix the date for you.
My lord, for lordship, we have got the original. My lord, we may also give it to my lord's office. These originals are here, lordship, for your lordship's perusal.
Don't give us originals.
Lordship, then we have got authenticated
We will take an inspection of the originals.
You take inspection, that's all right. We don't want to keep.
So, my lord, what I am humbly submitting is, my lord, I duly attested by the notary, lordship, we are handing over those copies to my lord's office. Well, may we file it with a small, we have already craved leave of those and we have given the relevance of those documents.
With a small affidavit, with a short affidavit, yes, better, better.
Then, my lord.
Mr. Trivedi, learned senior advocate appearing for, you're not appearing in your capacity as...
No, it is a private matter. Government has given me this liberty because I don't come within the category of law officer, but I can do private practice.
Best of both the world.
Best of both. Learned senior advocate appearing for the appellant has produced certain documents as we had directed by our order dated May 19, 2025. Stop. We think it will be better if the appellant files a short affidavit annexing thereto copies of such documents, authenticated copies of such documents. Stop. A copy of such affidavit be an advance copy. Advance copy of such affidavit be made over to the learned advocates representing the respondents. Paragraph lists this matter once again on
1 week.
June 16.
And Lordship will be at liberty to take inspection of the originals.
Paragraph, the respondents would be at liberty to, respondents or their learned advocates would be at liberty to take inspection of the originals of the documents which the appellant proposes to produce with the affidavit.
I'm grateful.
As indicated above.
I'm wishing your lordships very relaxing and happy holiday.
Thank you very much.
I may not appear before your lordships tomorrow, Miller.
Oh, you may not come tomorrow.
No, I will come tomorrow, Miller, but I may not get an opportunity because Miller knows, Miller, my lord's previous determination, I was more there.
Very well.
I'm grateful.
Item number 32.
Well, I was addressing your lordship in item 32. Well, your lordships were hearing this matter Well, I was under the impression that, my lord, matter may not be called on today. I am ready to go on with the matter, but will your lordships, my lord, hear it today?
No, not on the virtual mode.
Yes, my lord. Then kindly, my lord, keep it
Are
immediately on
you
the
south of France?
No, my lord. I'm very much here. Well, I was held up in something else. I thought I'd come in a little later, but
You are for the appellant.
I'm for the appellant. I had started addressing your lordship already.
Immediately
You know,
after
it's
the
a MSME, my lord, arbitration award.
Yes. Immediately after the vacation,
Yes, my lord.
12th of June.
Grateful.
Is it my lord's pleasure to fix a time? No.
Not immediately. Once it's taken up, we'll see. Today is the penultimate day before the summer vacation stop. Mr. Shah, learned senior advocate representing the appellant, as well as Mr. Chaudhuri, learned senior advocate representing the respondent, say in unison that hearing of this matter will take some time. Paragraph lists this matter once again on June 11. Retaining its position. June 11, 2025, retaining its position.
Grateful.
Item number 33.
My lord, in item number 33, my lord, I beg to appear on behalf of the official liquidator. My lord was to direct us to file an affidavit. My lord, Mr. Mitro is there. Mr. Shouhardo Mitro is there to file the affidavit, my lord.
The affidavit in opposition, I am filing the affidavit in reply, my lord.
Reply to that?
Yes, my lord. A very short issue, my lord. What is happening?
Order to down, Baba.
My lord, before my learned friend starts, I beg to submit, my lord, this application may not be entertained by your lordship. In the scope, it is not.
My application.
What are you doing on the virtual mode? Oh, it is EA.
Yes, my lord. That why ex-workers admitted claims, my lord. And already an order is existing, my lord, on 3rd October 2023, my lord. What have records are transpired, they have already disbursed the amounts to the appellants.
Mr. Mukherjee, you come and argue physically.
My lord, would it be your lordship's kind pleasure to keep it just immediately after the vacation?
9 June, reopening day.
Grateful, my lord.
What
Well,
are you
I'll be there.
Key file kullu.
Affidavit in opposition and reply, my lord.
No, key file. Is it file?
They have filed the opposition, my lord.
What a key?
Mm-hmm.
Affidavit in opposition as well as affidavit in reply filed in court today. We kept with the records. Paragraph. This matter once again on June 9, 2020. Retaining its position. Stop.
Grateful, my lord. We'll be there.
Item number 34.
To appear on behalf of the appellant lordship. Mr. Jishnu Shah, learned senior counsel is
Kindly keep it after the vacation. We have not started arguing this matter yet.
Yes. On the request made by learned senior counsel appearing for the appellant, let this matter stand adjourned and be listed again immediately after the summer vacation.
Grateful.
Very well. Again on June 10.
June 10.
26.
Grateful.
Hey, about 2026 लिखे दियो ना.
Yes. I was wondering.
Item number 35.
35. I appear for the respondent, my lord. I'm led by Mr. Bose. Your lordship was hearing this, my lord, in reply to my lord, Mr.
Mr. Tilak Bose.
Mr. Moinak Bose.
Moinak Bose.
My lord, this is with regard to that
execution matter, my lord, payment made already to corporation.
Oh, yes.
Double payment made.
Yes.
Everyone was, why did I make payment to corporation?
Yes.
Mr. Bose is on legs, my lord. This matter will take
Both legs.
my lord, in court. Court number 8, my lord. If your lordship kindly takes it up after the vacation, my lord, this will take some time.
On the request made, you are for the respondent. Made on behalf of the respondent, and considering that today is the penultimate day before the summer vacation, let this matter stand adjourned and be listed again on June 11, comma, retaining its position.
And only
Keep
one
your
thing,
time.
my lord, my juniors' names have not gone down in the last day's order.
Chi,
This is
chi,
the
chi,
Canada
keno?
Bank.
Ish.
This will be very important, my lord.
Very important. কি করবে?
এইটা থেকে
এখানে বলে দেবো লাস্ট দিনে কি ওর ডেটটা কি ছিল দেখি
last date টা কবে ছিল?
Last order.
19th. 19th ছিল।
in the order dated May 19, 2025, the name of ওনার নামটা বলো
তিনজন অনেকে আছে।
Oh, the names of learned advocates who assisted Mr. Sen, learned senior advocate, have not been recorded. Stop. কি করে এটা কারেকশন করতে পারবে নাকি? আচ্ছা, we record that on May 19, 2025, এই নামগুলো দিয়ে দেবে, learned advocates appeared along with Mr. Shakku Sen, learned senior advocate for the appellant.
Item number 36 and 37.
36 and 37, Lordship, we are out of time in filing our affidavit in reply to the in connection with Order 41, Rule 27. Lordship,
when were you required?
Lordship, a week back, my lord.
Week back.
At least
All
a
right.
week back.
We'll extend the time. And
Lordship extends the time and it keeps it after 15th. Lordship, I am led by Mr. Abhrojit Mitra, my lord. He will be back on 11th. He said that if it can be fixed after 15th, my lord, any day. Paper books are already filed.
Antarctica or South Africa? Where is he going?
I have not inquired.
You should know he's leading you.
Yes.
Hey, you're for the appellant.
Lordship.
On the request made by learned advocate for the appellant, the time to file affidavit in reply is extended till June 12, 2025. Stop. Paragraph. List this matter once again on June 18, 2025. দুটোতেই same order হবে 35 or 36. আবার 37 আছে তো।
There are two.
What two? There are three.
36 and 37.
Oh, sorry, 36 and 37. Sorry.
I give the respondent number 1.
Item number 38 to 40.
There are 3 appeals.
Lordship, 38 is my appeal, my lord.
I'm the plaintiff. I succeeded in the suit. Suit is the relief is for payment of a sum of money.
Money suit, ma'am. Money suit, ma'am. It's a decree against me, ma'am.
But Mr. Mitro's client has preferred an appeal saying that she is not liable to pay. Now, there was a Citibank who's also a co-defendant in the suit. My prayer was Citibank was a co-defendant in the suit. My prayer was the decree should have been passed jointly against Mr. Mitro's client as also against Citibank. Whilst holding that Citibank appears to be in connivance with Mr. Mitro's client, or words to that effect, if not exactly, the learned single judge has merely let Citibank off by directing them to pay a sum of rupees 1 lakh. So we preferred a cross objection against that. Citibank, of course, has also preferred an appeal saying that that 1 lakh also should not have been paid. In fact, we were given liberty to execute it, but we chose not to execute for a sum of rupees 1 lakh till such time that the appeal is heard.
And the money decree was for what sum of money?
25 lakhs plus interest. It works out to a larger figure.
So what do you propose to do?
The point of law is very simple and small. Mr. Mitro's client was a nominee in a bank account. I hold the succession certificate so far as that particular sum of money is concerned. He could have at best, my lord, held that money as a trustee. In spite of that, my lord, the money was given to Mr. Mitro's client by the bank. So I got the decree in my favor.
My defense is that I was under a statutory obligation to pay to the nominee. So my lord, I shouldn't have been saddled with any, either by making me a party or by any cost of 1 lakh or so.
We'll be happy to hear if you are happy to argue today or after vacation, up to you.
12th.
12th of
June. 10th, I think 12th
of June.
12th of June. We'll argue it, man. I know. Nominee. And there will be another issue. I will be arguing that under Section 15 of the Hindu Succession Act, the asset in question was inherited from the parental side of the lady. So, and the lady died without issue. The husband predeceased. So that, there are two issues. One, the nominee, and the other one
How
is
can there be two issues? You say died without an issue. Hey, dekho.
Makes it 13.
On the joint request made by learned advocates for the parties, comma, let these matters stand adjourned and be listed again on June 13, 2025.
13th run হবে রাজার আর যাওয়ার আছে 12
একসঙ্গে করে দাও 12 June 12 এই কৌশিক এটা কি একটাই কম্বাইন্ড অর্ডার হচ্ছে দেখে নাও না
12th
great Item 41.
This is my appeal. This is my appeal. You are appealing virtually. This is my appeal from a section 34 dismissal which I have suffered. It's an MSME award. The principal ground of my appeal is that the MSME Facilitation Council, while granting the principal sum of ₹20 lakhs, has delegated power to a chartered accountant for calculation of interest and the idle charges, which cannot be done, Your Lordship, under the Arbitration Conciliation Act. There is no delegation of power. So the calculation of interest and the idle charges goes about more than 50 lakhs. Principal is 20, interest is 50 lakhs. That cannot be the part of the award. I am saying that, so the arbitral award on that count is perverse. So I have taken a section 31, but this legal ground was not taken, Your Lordship. I was not there at that point of time, but it's a legal point I'm taking in the appeal. So on that score, Your Lordship, the award cannot stand in the eyes of law. There are judgments of Calcutta High Court itself.
Yes, it is all very well, but when will you come and argue the matter?
So Lordship will keep it any day after the reopening, any day. I have already secured this sum. 2 crore I have deposited by way of a bank guarantee. 2 crore is like as deposited.
This appeal is directed against a judgment and order of a learned single judge dismissing the appellant's application under Section 34 of the Arbitration and Conciliation Act, 1996. Stop. Learned advocate for the appellant says that hearing of this appeal will take some time. Stop. Today being the penultimate day before the summer vacation, he suggests that this matter be listed immediately after the summer vacation. Paragraph lists this matter once again on June 10.
Grateful. Prayer, if I could make, it's a 2017 award set aside in 2024 because the 34 was pending for all this while. I am an MSME concern, that side of the vacation, if some precedence or some time could be fixed, if I could humbly pray, it's my humble.
What do you want? Fixing of time?
If it's
Chalo, next.
Oblige.
Grateful.
Personal matter, item number 30.
Right number? 30. Oh. Tell us. Which day?
Reopening or day after? Reopening or thereafter? 10th or 11th?
What do you want?
Can I make that prayer?
So whose prayer is this? Joint. On the joint request made by... Huh? Oh, no. One we have said yes yesterday.
That's exactly what I said.
On the joint request made by learned senior counsel appearing for the parties, let this matter stand adjourned and be listed again on June 11.
Item number 42.
That one was different.
I know, but
No, Mr. Yes, next. 30,
My lord,
42.
My lord, 42, I'm praying for after vacation, lordship.
You are for the appellant?
I'm for the appellant, my lord.
On the request made by learned advocate for the appellant, comma, let this matter stand adjourned and be listed again immediately after the summer vacation.
Deeply obliged.
43,
Next.
44.
Lord, I for the appellant.
Yes.
But my suit before the High Court, my lord, was dismissed on the grounds of, my lord, Order 2, Rule 2, not having been obtained in a prior suit, and my lord, also, my lord, this being a commercial suit. My lord, I had filed, my lord, a suit, my lord, before the Sirampur Court, claiming, my lord, certain breach of obligation on the part of defendant number 1 under a government order. But the defendant number 1, my lord, is Hindustan Motors.
Hindustan Motors is still functioning.
Hindustan Motors? Yes, my lord, it's just selling of its land, basically. So I had purchased, my lord, 314 acres out of their, my lord, entire bulk of land, my lord, in Uttarpara for developing a township. The government, my lord, by an order of, my lord, 2006, September 2006, my lord, had granted them permission. There were certain obligations, my lord, which they had to do under that 2006 government order for us, my lord, to really develop, which they hadn't done. So, my lord, in breach of that, my lord, I filed a suit. In the High Court, later, I filed a suit, my lord, because for out of that 314 acres, 108 acres, my lord, was with a municipality, my lord, Kotrang municipality, my lord, which is number 2, where, my lord, they had not paid, my lord, the municipal dues. So I paid that. And, my lord, I filed a High Court suit for that. Now, my lord, the learned judge thought that, my lord, I should have obtained leave under Order 2 in the previous suit, and on the ground, my lord, has dismissed it. And also said, my lord, because in the High Court suit, my lord, we said that I'm entitled to commercial rate of interest. It's a commercial transaction. Therefore, I should have interest at quite. We always make that pleading and said that I also hold the great respect, my lord, to the learned single judge, my lord, not a little sketchy, my lord, if I say so, my lord, and also, my lord, held that therefore it's a commercial suit because you yourself said that it's a commercial transaction, my lord.
My lord, I'll indicate. I appear for the respondent. My lord, the cause of action in both the suits arise out of the same sale deed.
Sir, we are asking, are you today prepared to do the matter or not?
Can come back after vacation.
No. We are happy to hear you. Whatever. Make no mistake. It's not that we are suggesting that. But after Mr. Banerjee argues, don't seek time saying that I am led by such and such. If you want time, we'll give you time, but not after hearing.
Learned friend is only appearing.
Oh, you don't have a leader. No. Oh, I see. What do you propose to do?
Well, Lord, whatever is convenient, Lord,
we can hear you, no problem.
Lord, I can. The impugned order is at 201.
Paper books are there.
Yes, my lord, we filed paper. Thank you.
হ্যাঁ ওটা মেমো থেকে তো আবার কি ফিক্স আছে ও
মামলা ফিক্স আছে হ্যাঁ
I'm told, my lord. Yes, 12:30. So no point starting today.
My lord, whatever is convenient. My lord, if another matter is fixed, my lord, perhaps.
Yes, Mr. Chakraborty is here. We can see the tip of his head. Yes, we can start with your matter.
Yes. My lord, this is also a very short point. Any day, my lord. Then after, my lord, vacation, my lord, keeps, my lord.
It'll be in the list. We'll just say. কিছু বলবো না কি বলবো not today and tomorrow it will continue in the list ওই তোমায় যেটা বলেছিলাম ওই গ্রুপগুলো একটু উলটপালট করো তো ঠিক আছে
tomorrow, my lord.
You want to do tomorrow? So we said not today and tomorrow, or not this week. Or not this month?
Yes, my lord. As long as, my lord, anything else doesn't follow. Not this year, my lord, will have, my lord, repercussions.
Item number?
And also respondent and refused to accept that they have appeared. I have 45.
Time to file paper books is extended. Huh? File it in the department. Is extended till till May 23. Calcutta 30 tarikh. Till May 23, 2025. Top copies of the paper book be made available to learned advocates for the respondents.
They appear. Last month, he refused, advocate record refused. He told Mala, he client directly.
After this order, if they refuse, they'll do the matter without paper books. Yes. All right. Eh? Oh, let the appeal be listed once again on June 10. Paragraph, since the respondents are not represented today, comma, learned advocate on record for the appellant shall communicate today's order to the respondents and or their learned advocates. Dago 12:30.
Appellate side fixed matter 12:30. Item number 1 and 2 of commercial division.
I have concluded my submission.
Yes, today for reply.
Mr. Mitra starts. Only thing, I am not adding anything anew. In support of my submission on the interpretation of Order 13 and Rule 1 and 2, read with Order 13 and Rule 3. The celebrated judgment, my lords are aware of Delhi Municipal Corporation. I am just referring to that. This is 1993, Volume 3, Supreme Court Cases 161. Agree করে দিন 1993 Volume 3 কেসে 1993 Volume 3 Supreme Court Cases 161, paragraphs, my lord, 35, 30, 31, 32, 33 and 34.
Shiv Kumar Chadda, huh?
The interpretation, when injunction can be granted, when can we issue?
Paragraphs?
Paragraphs 35, 30, 31, 32, 33, 34. এটা বলবি আনচপ কি হয়ে যাবে তো হ্যাঁ দাদা একটু লাঞ্চ কি চলবে
Still us, for.
চেষ্টা করব
Can we release your learned friends till recess?
That is exactly what, my lord, I was being asked.
Oh.
Even if it is not, my lord, a day left, my lord, I think. ছুটি পড়ে করলে হয় না আপত্তি করবেন Lord, my learned friend wants it to be referred after vacation.
Immediately on reopening 9th.
But I have one submission.
Yes.
My lords are aware that whenever there is any money claim, any form in any manner, no injunction can be granted without the deposit. They have not deposited anything pursuant to the enhanced claim under the master circular after 2022. And they are merely running on the business in terms of your losses order. They let them deposit and let it be heard after fixation. I have no objection. Order 41, Rule 5, Sub Rule 2 and 3.
Yes, what do you say, Mr. Mitro? Mr. Chakraborty says that.
That's, my lord, appeal provision, my lord. We are Order 41, Rule 5, my lord, is for stay of a decree. Money was offered, my lord, at the rate, my lord, enhancing at the rate of 7%. That was offered. May I conclude my submissions?
You then better. So
I cannot, my lord, accede to that. Because the business has to be closed down. Now, my lord, the first point which was, my lord, urged before your lordships was, my lord, Order 41, Rule 11. The appeal has to be admitted. And, my lord, I personally thought, my lord, that as soon as, my lord, the appeal was taken up for hearing on the first day, and, my lord, an interim order was passed, my lord, that implies, my lord, that the appeal was admitted, because without that, there was no question of, my lord, any interim order being passed. In any event, that can be, my lord, if it is a technical irregularity, my lord, that can be regularized even today. Because under, my lord, Order 43, I am entitled to file this appeal.
Yes.
Even under the Commercial Courts Act, even under the Commercial Court Act, my lord, under Section 13, the proviso to subsection 1A, my lord, clearly, my lord, stipulates that, may I read out, provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure, as amended by this Act, etc.
Yes.
Now, my lord, the appellate side rules and, my lord, 2003 volume 3 Calcutta High Court notes was, my lord, cited. I have no quarrel about the proposition. I have already made my submission that as soon as, my lord, the order was passed by your lordship, it has to be deemed that, my lord, the appeal was admitted. Without that, my lord, the no interim order could have been passed. My lord, the second point before your lordships was, my lord, if I have noted it correctly, or the second preliminary point, was that, my lord, there is no cause of action. Now, kindly look into the plaint once, my lord. Kindly come to the plaint, which starts at page 193 of Can 1. Now, kindly,
no cause of action, did you argue, Mr. Chakraborty?
I submitted.
Because we don't have.
I submitted that in view of the adjudication on the self-same cause of action by the Constitutional Court.
Right. Because of the earlier writ.
That was, sorry, my lord. My noting is, my lord, that no notice of termination issued, so no cause of action.
That is subsequent point.
But you argued that point,
Yes.
no notice of termination.
Now, kindly look into the plaint, my lord. Kindly come to কি বল এই তোর তো বলার কথা ছিল, খেয়াল ছিল না।
Plaint.
My lord, that starts at page 193 of my lord Can 1. Kindly come to paragraph. তো পুরো প্লেন করতে হবে তাহলে। Good. Kindly come to page 203. Paragraph 28 onwards, my lord. The lordships got it. Page 203. The defendants have refused to accept license fees for the period 1st April 2023 to 31st March 2025 and have also refused to accept payment of license fee for the period 1st April 2024 to 31st March 2025 on the purported ground of the revised license fee being payable pursuant to the impugned demand notices dated such and such and such. The plaintiff has already paid an amount of rupees 12,54,000 towards the lawful license fee payable in respect of the said land for 23-24, taking into consideration the 7% annual increment in license fees payable in terms of the extant 2005 policy applicable to the existing licenses in respect of the said land. Then, my lord, kindly turn the page. Kindly come to page 204. Kindly come to paragraph 32 directly, at the bottom of page 204. The defendants number 1 and 2 are threatening to terminate the license agreement subsisting in favor of the plaintiff. The defendant number 1 and 2 are seeking to take coercive steps on the basis of the alleged default on the part of the plaintiff in making payment of license fees, despite the defendants number 1 and 2 themselves refusing to accept license fee at any rate apart from the illegally demanded license fees under the impugned demand notices dated such and such and such and such. By threatening such termination, the defendant numbers 1 and 2 are threatening to invade the valuable right of the plaintiff in respect of the license agreement. The invasion is such that compensation is money. Now kindly come to the prayers once. Prayer A, kindly look into declaration. Sorry, kindly give me a minute, sir. May I show paragraph 33 also, my lord? Page 206. Inasmuch as the plaintiff is under threat of the defendants number 1 and 2 taking immediate steps to terminate the license agreement subsisting in favor of the plaintiff, and inasmuch as the plaintiff requires urgent interim relief in order to protect its valuable right flowing out of the license agreement, the plaintiff prays for leave under section 80 subsection 2 of the Code of Civil Procedure to institute the present suit without serving a formal notice under section 8(1), etc. And my lord, it goes on. Upon the defendant, similarly, the plaintiff prays for dispensation of pre-institution mediation under Section 12A of the Commercial Courts Act. And then kindly come to the prayers. Pray they kindly look into a declaration that the plaintiff's license in respect of the land admitting such and such within Mouja, Ramrampur, jail number such and such is governed by the defendant number 3's master circular letter bearing number such and such dated 10th February 2005 being annexure P4 hereto and license fee thereunder is to be calculated for that of a private siding. Decree adjudging the said demand notices dated such and such being such and such as well as the letter dated 20th January 25 and 24th January 25 forming part of annexure P15 and 16 all issued by the defendant number 2 as void and have the same order to be delivered up and cancelled. But these are the prayers, my lord. In my respectful submission, the plaint shows cause of action. And my lord, that would also appear from the pleadings and the prayers made. In any event, my lord, as on date, there is no application under Order 7, Rule 11 of the Code of Civil Procedure. We are at the ad interim stage. They have possibly not filed any written objection to my application also, which is pending. Now, my lord, next it was submitted, my lord, that it was a license was granted and it's not a lease. Now, my lord, I can go into the facts, my lord. It would show, my lord, or kindly look into one of the documents once, my lord. Now, Prathomta. But kindly come to the first agreement. License. Or kindly before that, kindly come to page 26 once, my lord. The contract between the parties of May 2003 for manufacturing and supply of these slippers. Now kindly come to page 34 once. Clause 24. Licensing of railway land. 24.1 licensing of railway land required either for setting up a factory or stacking of sleepers near to the siding of the extent available and surplus to railways requirement will be dealt with under normal railway rules prevalent from time to time. 24.2 the land so licensed out to the contractor shall remain in his possession during the currency, extended currency of the contract. Now, this was the contract. The contractor will not have the right to subject, assign and mortgage the land license to him. There is no question of doing that, my lord. We have not tried to do that also. Now, under the manufacturing license, my lord, I am entitled to be in possession. And then comes, my lord, the next one is, my lord, 2004, the license agreement. Now, my lord, whether the effect is, my lord, is of a license or of a lease, my lord, that have to be gone into, my lord, not at this stage.
No, Mr. Mitra, I think Mr. Chakraborty, what he wanted to emphasize, even if it is a license,
yes,
it agreement provided for enhancement of.
Absolutely. I shall come to that. তাহলে এটা দেখিয়ে দিই হ্যাঁ 2004টা দেখাচ্ছি হ্যাঁ kindly come to the next agreement, my lord. Kindly come to page 36. Agreement of 23rd September 2004. Page 36, I'm sorry. Yes. Agreement number 27, etc. Land license agreement with Rampurhat PSC Sleeper Private Limited, Rampurhat, for setting up sleeper plant against railway boards contract number such and such, dated 23rd May 2003. The agreement I placed before your lordship. And PSC number such and such. This indenture made this day of 23rd September 2004 between President of India and Rampurhat. Then kindly come to the first recital. Whereas the licensor has entered into an agreement in writing with the licensee for manufacturing and supply of monoblock pre-stressed concrete slipper pre-tension type for broad gauge to RDSO drawing number such and such to suit 60 kg, etc. as per RDSO design and IRS specification number such and such, VD Railway Board's contract number such and such, and whereas in terms and conditions of the provisions of clause 24 to the said Railway Board contract dated 23rd May 2003, the licensor has agreed to grant, transfer and demise unto the licensee a plot of land measuring approximately 4.31 acres, etc. Then kindly turn the page. Kindly come to clause 3 at page 37. The licensee may apply for further renewal of license as well as license agreement as per Railway Board's norms well in advance before 31st March 2005. If it desires to enjoy the land license and renewal of agreement for the same purpose through Principal Chief's Engineer, Eastern Railway, Kolkata. The annual rent is fixed from time to time if not paid by the licensee in advance within the stipulated period, that is before expiry of the currency of the license for the next year. The Railway Administration shall be entitled to forfeiture of security deposit referred to above, realize the dues in yearly rental from the licensee's dues whatsoever. No right of termination. If I fail to pay, kindly, my lord, may I read out clause 3, the last 3 lines again. The annual rent as fixed from time to time if not paid by the licensee in advance within the stipulated period, that is before expiry of the currency of the license for the next year. The Railway Administration shall be entitled to forfeiture of security deposit referred to above, realize the dues yearly rental from the licensee's dues whatsoever. The next, provided that should the contract for manufacturing and supply of PSC supplier placed on the firm under Railway Board's contract dated 23rd May 2003 of the licensor for manufacture and supply monoblock, etc. in drawing number such and such, is terminated before the expiry of the license or not exceed beyond the initial order of license, will automatically determine simultaneously with the determination of the contract. Then kindly turn the page. Kindly come to clause 11 at page 38. In the event the licensee failing to comply with the terms or committing any breach of the Railway Board's contract number such and such for manufacture and supply of monoblock such and such, etc., it shall be lawful for the licensor to issue 1 month's notice to the licensee. On such determination, the licensee shall remove all his structures, fittings and materials, etc., if any, from the demised premises within 3 months from the date of such determination. So if I fail to comply with the parent contract, then only I will be removed. This was the contract. Now, so far as, my lord, the price variation is concerned, kindly come to the next page, clause 14. The license fee now fixed is provisional and may be revised upward at any time at the option of the railway, which licensee hereby agrees to accept license fee will be revised time to time as per Railway Board's instruction. But this is the only other clause. Now, my lord, there comes, my lord, a fresh policy, my lord, in 2005. Kindly come to page 52. Or, my lord, before that, my lord, kindly come to the earlier policy, my lord, which was prevailing at the time of grant. Kindly come to page 45 once. Kindly come to, my lord, page 46, clause 3, rates of license fees. License fee of plots will continue to be fixed at a percentage of the land value determined as per the procedure detailed in paragraph 4 below. The percentage now applicable to various types of plots will be as under. And my lord, the particulars are given. Now kindly turn the page. Page 47. Fixing of land value. As the end use of the land licensed for the above purpose is generally directly related to, kindly come to the fourth line. A market value would, however, be required to be taken to serve as a base value for working out rental fee payable. This shall be fixed on the basis of the land value of the surrounding areas as on 1st January 1985, as determined from the revenue authorities and or from the following. But then, my lord, the particulars are given. Then kindly come to next. The value so fixed shall be increased nationally every year. Notionally. Every year on the 1st of April, starting from 1st April at the rate of 10% over the previous year's value to arrive at the land value for the following year, based on which the license fee to be paid shall be fixed. Once the notional value has been so obtained, it shall apply to all plots at the station. However, for the metropolitan, it's not applicable. The next clause. Then, my lord, it was changed. Kindly come to the fresh policy at page 52. Now, kindly come to page 52, subject, policy on licensing of railway land for commercial plots, etc. Reference board's letter dated. Next, policy guidelines for commercial licensing of railway land, last issued vide board's letter dated 29th August 1995 in supersession of the earlier policy directive have been amended from time to time with a view to bring all such policy instructions under one umbrella. It has been decided to issue a master circular combining all the instructions issued so far as on the subject. Henceforth, railway should quote only the present letter for any further reference. Then kindly come to 2.3 at the bottom. Licensing of ordinary commercial plots connected with railway working, as indicated in paragraph 3 below, will be done with the personal approval of general manager in consultation with such and such. Periodical review may, however, be approved by DRM. Then kindly turn the page. Kindly come to page 53, clause 3. Rates of license fee. 3.1. License fee of plots will continue to be fixed as a percentage of the land value determined as per the procedure detailed in paragraph 5 below. The percentage applicable with effect from 1st April 2004 to various types of plots will be as under. Then kindly see the maximum is, my lord. First one is railway related activities such as city booking office, 6%. Ordinary commercial plot without structure, 6%. Ordinary commercial plot with temporary structure for stacking, storing, 7.5%. Open area, 6%. Steel yard, coal dump, bulk oil, etc., 7.5%, etc. Then kindly come to clause 5, my lord, next page, clause page 54. A market value would, however, be required to be taken to serve as a base value for the working out rental fee payable. This shall be fixed on the basis of the land value of the surrounding area as on 1st January 1985, as determined from the revenue authorities and from the following. Then what are the following? Evaluation of town planning department, actual as per PWD, etc. Now kindly come to 5.2. The land value as worked out shall be increased every year on the 1st of April, starting from 1st April 1986 at the rate of 10% over the previous year's land value to arrive at the land value of for the following year, based on which the annual license fee shall be fixed. From 1st April 2004 onwards, the land value shall be increased at the rate of 7% every year over the previous year's value. So till that day, my lord, till 2004, 10%, from 1st April, 7%. Land value increase. Then kindly come to, my lord, the last clause at that page. Revision of license fee. 7.1. As the notional land value will increase by 7% over the previous year's land value, as mentioned in paragraph 5.2 above, the license fee will automatically go up by 7% over the previous year's license fee from the 1st of April every year. Suitable provision with the schedule of payment due may be incorporated in the agreement. So 7% on the every year on the basis of land value, which was prevailing on 1st of April 2004, and that was done. That was prevailing till 2022. My client, my lord, had paid the money by increasing, my lord, 7% on the next year, and that was deposited.
But a new policy came in 22, he was arguing.
I shall come to that, my lord. Now kindly come to my lord, they raised last bill, my lord, for the period 1st April 2021 to 31st March 2022. That was paid. For the next year, my lord, they do not raise, my lord, any bill. Now kindly come to, my lord, page 1113.
This was payable annually or monthly?
Annually.
Annually, once.
Yes. Circulate that. Now, my lord, on 7th of November 2022, my client had forwarded a demand draft for 13,83,641 for the year 2022-23. It was deposited with them. Then, my lord, suddenly, my lord, after the lapse of 2 years comes a demand. Kindly come to page 124 once. One 28th of March 2024. Kindly see reference. Master Circular on Policy for Management of Railway Land, circular number such and such, dated 4th October 2022. In connection with the above, it is requested to deposit the current land license fee / lease charges to the tune of rupees 47,32,812 for the financial year 23-24 in connection with the using railway land measuring such and such at Rampurat. The statement of license fee has been worked out on this basis. Then, my lord, they say that the total land value is now 6 crore 68 lakhs. Now kindly come to the policy which they have referred to 4th October 2022. Now kindly come to page 111. 111. Master Circular on Policy for Management of Railway Land is their internal communication to enable integrated development of infrastructure aligned with PM Gati Shakti framework and to attract more cargo to rail. The extant policy for leasing, licensing and right-of-way of railway land have been simplified. The detailed guidelines of policy for management of railway land, etc. Kindly turn the page, kindly come to page 113. This is annexed to this letter at page 111. Page 113. Policy for management of railway land. Now kindly come to clause 2. Permitted uses of railway land under this policy. 2.1. General, all activities connected with railway working and activities which will promote railways cargo services shall be permitted. 2.2. Cargo terminal. Cargo terminals shall be permitted in accordance with the extant Gati Shakti cargo terminal policy issued by the Ministry of Railways vided letter number such and such as amended from time to time. 2.3. Cargo related facilities. All activities which use railway as a mode of transport for at least one direction of movement. Example, warehouses, storage facilities, silos, tanks, conveyor belt, decanting facility and other enabling facilities for cargo like railroad, weighbridge, truck parking, etc. shall be permitted. 2.4. Passenger facilities. Railway land shall be permitted for passenger facilities as per the policies issued by Railway Board from time to time. 2.5. Renewable energy and other activities required for railways. Sewage treatment plant, water recycling plant, etc. Renewable energy and any other such facility, etc. shall be permitted. 2.6. Infrastructure for public service utilities. Infrastructure for all public service utilities, namely electricity, gas, water supply, telecom cable, sewage disposal, drains, optical fiber cable, pipeline, road, flyover, bus terminal, regional rail transport, urban transport, and any other such infrastructure shall be permitted. Staff amenity. Then 2.8, cultural, social, and sports activity. Then kindly come to the next. 2.9, government bodies, departments. Railway land shall be permitted to infrastructure activities of government bodies, department for their own use. Social infrastructure, hospitals selected through a transparent policy, etc. Land interest, next, land entrusted to RLDA, commercial development of surplus railway land entrusted to RLDA in accordance with the rules of RLDA and the policies of Ministry of Railway shall be permitted. 2.12, Railtel Corporation of India for towers and other telecommunications. I do not come with this, my lord, within this circular. Kindly consider clause 2, my lord. The purpose for which the land was granted, my lord, does not fall within this.
All activities connected with railway working?
It's not, my lord, this sole, it's not an activity connected with the rail working, my lord, in my respectful submission. And my lord, kindly also 2.1, your lordships were, my lord, looking at all activities connected with railway working and activities which will promote railways cargo service shall be permitted. My lord, in my full submission, my lord, the work which I am doing, my lord, is not, my lord, for promoting the railway working or activities, my lord. Now, then kindly come to, my lord, page 114. 114. Assuming, my lord, I come under this. Under this circular or policy, kindly come to page 115, my lord. Clause 4. Market value of land. Market value of railway land shall be the prevalent circle rate, ready reckoner rate, guidance value of the railway land at the time of execution of the lease agreement if available. Otherwise, prevalent circle rate, ready reckoner rate, guidance value of surrounding land for similar classification activities shall be considered. For example, if surrounding land is classified as industrial use, then industrial rate shall be used. Note, in case the notified circle rate of the current year is not available, then last available circle rate, ready reckoner rate, guidance value as notified by revenue authority or as decided by district revenue authority shall be considered. 4.2, for cargo terminal, industrial rate if specified in that state shall be considered. If not specified, then any other rate depending upon the use of surrounding land as specified by state revenue office shall only be considered. In case 4.3, in case of cargo terminal, if logistics industry is given a special status and discount is given in a state, then railway shall also give same discount in that state.
It's continue after to finish it off today. We can reserve judgment. Come back at 2 o'clock. আবার ঘুমিয়ে পড়েছে।
May I have my lords kind leave to mention one matter, my lord?
2 minutes after 2 p.m. At 2 p.m. I have a very short bench with another learned judge. Maybe 5 minutes. That'll. Yes.
I'm sorry, my lord. I was trying to appear online today. I was not given access in the morning, so I was unable to mention, my lord. There is compelling urgency in one matter, my lord. Not appearing in your lordship's list, even though yesterday was the returnable date. My lord, this is a matter where I am given a contract to carry out demolition work and to, my lord, carry away with the salvage. That is my consideration for the work performed. Contract has been prematurely terminated, my lord. Third parties have been engaged to, my lord, lift away the salvage that I have, my lord, demolished. So, my lord, I will be left completely remedialess. If your lordships are inclined to take it up tomorrow, kindly, my lord.
Let it be listed tomorrow. Provide the number, etc.
Yes, my lord. Number my colleagues will hand up to you.
We are not hearing the matter now. Let it be listed tomorrow.
Please, my lord.
We are with him, yes.
There in the laws in the court, there was a small defect, typographical error, it has been corrected.
Sure.
My lord, one indulgence, my lord.
This is appellate side or appellate side?
No, no, item 24.
দেখে না। It will be, we cannot promise that it will be taken up. Let us see.
Lordship.
My lord, one indulgence, my lord. Item number 24, my lord. Item number 24, non-commercial.
Is what?
My lord, has recorded an order. My lord, it's my submission that I have made one submission that I have instructions that my client is paying. My lord, I have.
Your client is?
My client is paying. My lord, you'll recall that.
Yes. 3 months he said you have not paid.
My lord, will not record that, my lord. That, my lord, I have written a mail, my lord. It's a wrong submission from me. I humbly request.
মনে করি কে ছিল আমার মনে নেই। মনে থাকবে তো?
কথা বলুন।
Item number 1.
My lord, item number 1, I'm for the review petitioner, my lord. My lord, in this matter, Mr. Shubhi Shanal is appearing and the advocate on record is Mr. Orijit Bokshi. My lord, both of them are not available today.
Very well, adjourn. We can't promise you when we'll meet
Yes, my
again.
lord.
But accommodation is prayed for on behalf of the review applicant. Paragraph. Let this matter stand adjourned and be listed again after the summer vacation, whenever this bench assembles. What else?
My lord, I really apologize for the inconvenience.
Why should you apologize?
My lord, a special bench was constituted. I understand that.
And you sought for a special accommodation.
I'm sorry.
SAD 1. SAD 1 and 2. Commercial division, item number 1 and 2.
I was at page 115, my lord. The 2022, the guidelines or the circular, whatever it is, starts at page 113. I showed you, lordships, my lord, clause 4, 4.1. Kindly once come to market value of railway land shall be the prevalent circle rate, ready reckoner rate, guidance value of the railway land at the time of execution of the lease agreement. At the time of execution, that was done, my lord, in 2004. And then kindly once come to page 116. Clause 7.5. 7.5.1 kindly come to. 7.5 is migration of existing lease licenses, way leave permissions. Existing lease license holders of terminals, private sidings, private freight terminals, all entities currently using railway land for cargo activities will continue to be governed by railway extent policies, that is, annual lease license charges at the rate of 6% of MVL, with annual escalation of 7% of the remaining lease license period of 35 years, or period as mutually decided, whichever is earlier. The existing entities shall be given option to migrate to the new policy. the existing entity shall be given option to migrate to the new policy regime on transparent competitive bidding process as applicable for new cargo terminals, provided there are no outstanding dues. In such cases, the right of first refusal shall be with the existing licenses lessees for terminals, private sidings, PFTs dedicated to one customer and where competition is not possible on existing entities who do not want to avail the option as above. The annual lease charges shall remain unchanged. That is, annual lease license charges at the rate of 6% of MVL with annual escalation of 7%. I am squarely covered by this.
No, will this apply, Mr. Mitro? Because this says all entities currently using railway land for cargo activities.
Existing, sorry, Millard, you're
for new cargo terminals.
Existing 7.5.1
Yes.
Existing lease license holders of terminal, private siding, private freight terminal, all entities currently using railway land for cargo activities will continue to be continue to be governed by the railways extant policy, that is annual license, etc. 35 years. The existing entity shall be given option to migrate to the new policy regime on transparent competitive bidding process as applicable for new cargo terminal, provided there are no outstanding dues. In such cases, the right of first refusal shall be the existing license for terminals, private sidings, PFTs, dedicated to one customer. It's dedicated to me. And where competition is not possible or existing entities who do not want to avail the option as above, the annual lease charges. Now, my lord, according to me, my lord, I squarely come within this, my lord. In any event, this is today, my lord, we are really, my lord, going into, my lord, as if, my lord, a mini trial is being held. Which, my lord, the Supreme Court has also said that no, there is no question of mini trial at this stage. And kindly come to, my lord, page 76. Subject, page 76, my lord, subject. Deposition of license fee of railway land for temporary licensing of PSC sleeper private siding. There later. Now, my lord, once kindly come back to page 116. Sorry.
Yes. Page, sorry.
Kindly come back to page 116 once, my lord. Seven 7.5.1, last 4 lines or 5 lines.
Yes.
The clause I was placing. Last 5 lines. For terminals, private sidings, PFT is dedicated to one customer. And where competition is not possible. Now, there is no other factory there. Or existing entities who do not want to avail the option as above. Sorry, page 116. Justice right. 116, clause 7.5.1, last 5 lines. Now, my lord, again, these are, my lord, subject to trial. The trial has to be held. Till date, they have not filed any affidavit or written objection to my application, disclosing their defense. And my lord, kindly once come to the prayers which I have made. No, we talk dewa. Yes, my lord, kindly come to page 209, the prayers in the plaint. Kindly come to prayer F. My lord, I have wanted to pay at the rate, my lord, which comes on the basis of 7% enhancement per year after 21-22.
Prayer F.
Prayer F of the plaint and, my lord, prayer C of the petition at page 238. Now, my lord, next, my lord, if I understood it correctly, my lord, if I have understood it correctly, the next submission was, my lord, that there was transparency in assessing hearing was given. Now, my lord, my specific case is, my lord, that no hearing was given. And kindly...
No hearing?
No. Kindly come to the letters which I received. In paragraph 14, my lord, I have said no opportunity of hearing was given. And then kindly come to page 181 and 182.
Paragraph?
Paragraph 14, my lord, page 198.
Of the plaint?
Yes. Yes, sorry. Paragraph 14, it starts with, my lord, it's slightly difficult to read. Thereafter, without granting an opportunity of hearing to the plaintiff by a letter dated 20th January 2025, the office of the defendant number 2 purported claim. And if your lordships are pleased to come to the documents, my lord, this 20th January letter, my lord, is at page 181. It also does not speak of any hearing. Subject reference High Court's order. Then, in connection with the above subject matter, Honorable High Court Calcutta had ordered to form a standing committee for dispute resolution, which is mentioned in Schedule 8 of the Master Circular. Standing committee has submitted the report, etc. And then that's true. It is stated that there is no dispute regarding interpretation of the policy and land license fee for the year is authentic and valid. And then comes, my lord, the next one, page 182. Hmm? Last, kindly come, hence it is requested to deposit the land license fee for the year 2023-24 of rupees 47 lakhs. Now, my lord, next, my lord, it was submitted before your lordships that, my lord, I am stopped. Now, my lord, I really do not know, my lord, before this letters were issued, when the demand notice was issued, I filed a writ. My lord, the demand notice is, my lord, at page 124.
Similar. It's basically res judicata, he argued.
Yes. No, there is no question of res judicata. Kindly come to, my lord, the demand notice. I raised a protest. There was no response to that. I filed a writ. Now, kindly come to, my lord, the writ, my lord, I have annexed. Kindly come to page 143. The prayers are at page 170. Kindly omit prayer A because that is certiorari. Kindly come to prayer B, a writ of at
177.
170.
170.
Sorry, my lord,
Yes.
Kindly come to page 171. Prayer B, a writ of and or in the nature of mandamus do issue commanding the respondents and each of them to rescind, revoke, cancel, set aside, recall the impugned demand notice dated such and such, in any manner whatsoever, then writ of mandamus not to take any step. Then kindly come to the order passed in this writ, that is, my lord, at page 175. Kindly come to prayer 8. Sorry. Sorry. Kindly come to page 178. Kindly come to page 178. At the top, clauses 8 and 9 are also quoted below. Dispute resolution in case of any dispute arising in interpretation of the policy, land rates, land area, etc. A standing committee of 3 JAS, SG officers of engineering, finance and usual department of concerned railway division shall examine all the issues and submit recommendation to the DRM, whose decision shall be final and binding on all the parties. It is true that the writ court cannot entertain a dispute where there is an alternative remedy in terms of the contract and also in terms of the policy, which the petitioner also relies upon clause 7.5.1 deals with the charges payable by existing licenses. Whether the petitioner could be treated as an existing licensee is a matter of evidence. The dispute resolution clause states that in case of dispute arising out of interpretation of policy, land rent, etc., the standing committee would examine the issue and submit recommendation to the DRM. Then under such circumstances, as the petitioner has already raised a dispute and other disputes before the Divisional Railway Manager, Eastern Railway, Howrah Division, on 2nd May 2024, the writ petition is disposed of by directing the authorities to proceed on the basis of clause 8 of the policy which has been quoted herein above. In the instant case, the petitioner claims to have paid the license fee up to 2022-23, but thereafter the authorities allegedly refused to accept. Then kindly come to 13. The competent authority shall decide the dispute, etc. Kindly come to the, my lord, last 6-7 lines. Or, my lord, 10 lines. The divisional railway manager Howrah shall be served with a copy of the writ petition and server copy of this order. The authority shall proceed on the basis of the dispute resolution clause. Hearing shall be given to the petitioner and to those authorities who had allegedly issued purchase order to the petitioner and allow the petitioner to enjoy the land of the railway at Rampur at Mauja.
The writ court did not decide
No,
the issue.
nothing.
All right, next point.
Yes. Now, my lord, in this context, my lord, a decision reported, my lord, in Monopatro was relied on. ছিল বলতো এটা তো নয় oh yes my lord, possibly paragraph 18 was relied on, but before that kindly come to paragraph 11 once.
11 of?
I'm sorry, my lord. The Monopatro, my lord, decision reported in Monopatro SC 7567 of 2008.
Would that be 2008 11 SCC page 1?
Yes, must be, yes. Yes.
Oh, is missing.
Mandali, Raganna and others versus T. Ramachandra and others.
Yes.
Now kindly come to, my lord, paragraph 11. Mr. So-and-so, learned senior counsel appearing on behalf of the respondents, on the other hand, submitted. The partition having been effected as far back in 1924 and the principal respondents having been in possession of the properties from 1956 till 2003, when the granted lease in respect of 1/3 of the property, the impugned judgment should not be interfered with. Even an advertisement was issued for sale of 1/3 of the land in the year 1985 and the deed of sale was executed on such and such. Admittedly, as would appear from the photographs appended to the counter affidavit, huge construction have come up on the land in question, and as such, there was no reason as to why the appellant had kept quiet for so long. A large number of documents have been filed before the court below, before the courts below, not only showing dealing with the properties, but also showing execution of the deeds of lease, etc. Now, in this context, kindly come to paragraph 18, which was relied on. While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, namely existence of a prima facie case.
Mr. Mitro, while I was going through the affidavit,
yes,
I find this, the father of the deponent. I have had an occasion to appear against him in a matter.
I don't think that, my lord, there can be any difficulty. Not in this matter. It could not have been in this matter.
No, it was not in this matter, in a bank matter.
I can, my lord, take responsibility of saying that my client cannot have any difficulty. But it's entirely my. Huh?
তাহলে শুনে নি রেকর্ড করে দিবি
Of course.
Apprised Learned Council, fourth party. We'll record that.
My junior was possibly in that matter also State Bank. In State Bank matter, my lord, but
he was for appearing for
the
Jajodia.
Yes, kindly keep that on record. Now I have instruction, my lord. That was, my lord, I was exercising the council's prerogative. Now I am, my lord, I have instruction that there is no difficulty. Now kindly come to paragraph 18 of that judgment. While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation thereto, namely existence of a prima facie case, balance of convenience, and irreparable injury, it must also take into consideration the conduct of the parties. Grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with the properties exclusively ordinarily would not be entitled to an order of injunction. The court will not interfere only because the property is a very valuable one. We are not, however, oblivious of the fact that grant or refusal of injunction has serious consequences depending upon the nature thereof. The courts dealing with such matters must make all endeavor to protect the interest of the parties. For this said purpose, application of mind on the part of the court is it. Now, my lord, that is why I placed paragraph 11 that, my lord, the property was being dealt with here in this matter. The property was being dealt with from 1920s. That is what, my lord, paragraph 11, my lord, records. So, it cannot be said in my respectful submission, in this case, my lord, it cannot be said that, my lord, there was, my lord, any delay on my part, forgetting about irreparable delay in coming up before the court. I challenge, my lord, the notice demanding the additional fees by filing a writ.
March and June were the two notices.
Yes, I challenged it by filing writ.
In July, no,
Yes.
when? Anyway.
It was disposed of in July. Then, my lord, their order comes, my lord, now in January. January, no, February. Sorry, 20th January, yes. 20th January, 24th January, I filed the suit. Next, my lord, it was submitted before your lordships that I am an agent, my lord. Provisions of Contract Act, my lord. Section 182, 201 and 203.
203.
Yes. Kindly come to page paragraphs, section 182. Agent and principal defined. An agent is a person employed. Sorry. Section 182. Agent and principal defined. An agent is a person employed to do any act for another or to represent another in dealing with third persons. The person for whom such act is done or who is so represented is called the principal. My lord, principal, my lord, possibly does not apply in this case, my lord. Then they have relied on 201, section 201 and 203.
Again, agency.
Agency. And my lord, 204 also, my lord, 204, 202 deals with agency coupled with interest here, my lord. I have some interest in the matter. Now, in this connection, my lord, possibly reliance was placed on 1989 4 Supreme Court cases. বাকি বইগুলো বার কর। Page 603. Paragraphs 13, 14, and 17 and 18 were relied on. Again, my lord, it's on agency, the right of an agent, my lord, on termination, my lord. In my respectful submission, it does not apply in the facts of our case, my lord. Now, my lord, next it was 15 শব্দে কি লিখেছে 15 শব্দে কি হ্যাঁ এটা কিসে দেখিয়েছিলেন বলতো Oh. Well, next was which was relied on is the decision reported in 2015, volume 7, Supreme Court cases, page 7 to 8.
Public law element.
Yes. 3 paragraphs, my lord, 53, 54, and 55. May I hurriedly go through it, my lord? We have to keep in mind that the contract in question, sorry, paragraph 53.
Volume 7.
2015, volume 7, Supreme Court cases 7 to 8.
Yes. Paragraphs you want to cite?
53, 54, and 55, 3 paragraphs were, my lord, referred to. We have to keep in mind that the contract in question is governed by the provisions of Article 299 of the Constitution. There are formal contracts made in the exercise of the executive power of the Union or of a state, as the case may be, and are made on behalf of the President or by the Governor, as the case may be. Further, these contracts are to be made by such persons and in such manner as the President or the Governor may direct or authorize. Thus, when a particular contract is entered into, its novation has to be on fulfillment of all procedural requirements. No doubt there is an exception to this principle, namely, even in the absence of a contract according to requirement of Article 299 of the Constitution, doctrine of promissory estoppel can still be invoked against the government. However, no such case is pleaded by the appellant. To dilate upon the aforesaid proposition, further we take along third facet of this issue, as to some extent they are overlapping. Fact remains that even when MOPNG requested MOF for giving consent to amend the contract, no such authorization came from MOF. Whether in such a case can the court issue amendments? As noted above, The contention of the respondent is that PSCs are in the nature of a contract agreed to between two independent contracting parties. It is also mentioned that before the signing of the PSCs, the approval of the cabinet is obtained, which reflect that the PSC has submitted to the cabinet has the approval of one of the contracting parties, namely Government of India. In this case, when it is signed by the other party, it means that it has the approval of both the parties. Therefore, a contracting party cannot claim to be oblivious of the provision of law or the contents of the contract at the time of signing, and therefore later on cannot seek retrospective amendment as a matter of right, when no such right is conferred under the contract. Even the doctrine of fairness and reasonableness applies only in the exercise of statutory or administrative actions of the state, and not in the exercise of contractual obligation and issues arising of the contractual matters to be decided on the basis of law of contract and not on the basis of administrative law. No doubt, under certain situation, even in respect of contract with the state, relief can be granted under Article 226. We would thus be dealing with this aspect in some detail. Law in this aspect has developed through catena of judgments of this court, and from the reading of these judgments, it would follow that in pure contractual matter, the extraordinary remedy of writ under Article 226 or Article 32 of the Constitution cannot be invoked. However, in a limited sphere, such remedies are available only when the non-government contracting party is able to demonstrate that it is a public law remedy which such party seeks to invoke. In contradistinction to the private law remedies simpliciter under the contract, some of the case laws to bring home this cardinal principle is taken. Right, it's on a different question altogether, as would appear from these paragraphs. It was a question of amendment of the contract, whether it could have been done or not. And my lord, whether the writ lies. My lord, today we are before a suit court, my lord. It cannot be said, my lord, a suit does not lie. Now, my lord, next, my lord, it was submitted before your lordships that I have not challenged the master circular, my lord. I was not required to challenge the master circular. I have shown the provisions of the master circular. I am relying on those provisions. So there was no question of challenging the master circular. And my lord, possibly the last submission before your lordships was, my lord, on section 12A, that, my lord, no leave ought to have been granted. Now, again, no application has been filed, my lord, for revocation of leave, my lord, granted under section 12A. Kindly come to page 237, my lord. Some paragraphs of the petition I would like to show your lordships. Page 237, kindly come. I had shown you, lordships, the plaint, the pleadings in the plaint. Now kindly come to the pleadings in the petition. Kindly come to paragraph 34 at page 237. The plaintiff states and submits that there exists an imminent threat of coercive steps being taken by the defendants in respect of the license agreement, thus requiring urgent intervention of this learned court. The defendants are continuing to persist with their ex facie illegal and exorbitant demand for license fee, towards the extent policy circulars. The ex facie arbitrariness and malafide of the defendants are required to be injuncted in order for the lawful license of the plaintiff from being terminated. The defendants are intending to induce breach of the license agreement without any fault or laches on the part of the plaintiff. Injunctions are required in order to protect and preserve the subject matter of the suit. There is grave urgency in the matter in view of the aforesaid acts and or inactions on the part of the defendants. The right of the plaintiff to continue utilizing the land in terms of the license agreement is being threatened by the defendants. The plaintiff has learned from reliable sources that the defendants number 1 and 2 are intending to act on the letters dated 20th January 25 and 24 January 25 and are seeking to terminate the license existing in favor of the plaintiff with the close of the present financial year 24-25. Such termination is being threatened in furtherance of the defendant's illegal non-adherence to the terms of the 2005 circular and the balance of convenience, inconvenience, etc. These are the, my lord, in this connection, my lord, may I rely on a judgment of the Honorable Supreme Court, my lord, reported in 2024, Volume 5, Supreme Court Cases, page 815. হ্যাঁ না দিলে কি করে ছেড়ে দিলাম আজকে kindly come to paragraph 5 at page 818. Your lordships must have considered this minimum of 1,000
scope of revocation.
Paragraph 5 to my lord 12, my lord, these are
limited window.
5 to 12 are the relevant paragraphs in this context.
Statutory force. Railway circuit statutory. Article 73.
Article 73. My lord, I missed it, my lord. Possibly, my lord, an argument was advanced, my lord, on Article 73 of the Constitution of India.
Article 228 also read
Yes,
with
220. I'm sorry, my lord, I missed it.
Read with Order 27 capital A CPC.
Yes. Yes. May I? ঠিক আছে দিন Kindly come to Article 73, 74. Subject to provisions of Constitution, the executive power of the Union shall extend to the matters with respect to which Parliament has power to make laws and to the exercise of such rights, authority and jurisdiction as are exercisable by the Government of India by virtue of any treaty or agreement, provided that the executive power referred to in subclause 1A shall not save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also power to make laws, until subsection Article 2. Until otherwise provided by Parliament, a state or any officer or authority of a state may, notwithstanding anything in this article, continue to exercise in matters with respect to which Parliament has power to make laws for the state such executive power or function as the state or officer or authority thereof could exercise immediately before the commencement of this Constitution. Then 74 deals with Council of Ministers to aid and advise President. Then Article 228. Transfer of certain cases to High Court. If the High Court is satisfied that a case pending in a court subordinate to it involves a substantial question of law As to the interpretation of this constitution, the determination of which is necessary for the disposal of the case, it shall withdraw the case and may either dispose of the case itself or B. determine the said question of law and return the case to the court from which the case has been so withdrawn, together with a copy of its judgment or such question, and the said court shall on receipt thereof proceed to dispose of the case in conformity with such judgment. I don't find, my lord. The suit can be transferred here also. I have no difficulty. We can, my lord, expeditiously, the suit can be heard out here.
We mind.
And my lord, section 27A of the CPC, sorry, order. Nahi. Judge, order 27. Order 27A, my lord, suit involving a substantial question of law as to the interpretation of the Constitution or to the validity of any statutory instrument, my lord, in my respectful submission, does not apply in the facts of the case. It's a purely contractual dispute. And my lord, it has, my lord, no, my lord.
No, what Mr. Chakraborty argued, the master circular is a statutory instrument.
I have not challenged it. I have not challenged it. I am not required to challenge it. No mini trial, my lord, Supreme Court says.
So that is all.
May I hand it over? Yes. 2001, Volume 5, Supreme Court Cases, page 568. Paragraphs 4 and 6. Paragraphs 4 and 6. Well, this is well settled. I don't think that. HON'BLE 1.5 SCC 568. Well, those are my responses.
4 and 5, para 4 and 5.
4 and 6.
4 and 6.
Particularly paragraph 6, the opening lines. Yes. Good. Chuti laged dine.
Mr. Chakraborty, anything more or shall we? Mr. Chakraborty, anything more or shall we close the hearing?
Yes. I am just taking lots of 10 minutes time to give reply. Now, what is the case before your lordship? What is the case? Initially, when the suit was filed with waiving notice under Section 80 CPC and also Section 12 capital A of the Commercial Courts Act, then it was fixed immediately after 4 days for hearing the injunction application. That was possibly 7th April, if I remember right, 2025. It was placed on 11th. Now, on 11th, we appeared and said we should file an objection. And that is why it is deferred to 6th June. So, both the orders are challenged as refusal of injunction. Now, my lord, with great respect to Mr. Mitro, the basic principle of grant of injunction or refusal of injunction, which has been categorically enumerated in the 1993 judgment, that when there will be an urgency which is coming within the scope and ambit of Order 13 Rule and 2, extreme urgency, because the lordships are aware there are 2 types of interim orders in a suit when a suit is filed: temporary injunction and ad interim injunction. Temporary injunction is coming within the ambit of Order 13 Rule and 2. It is done on exchange of affidavit when the prima facie case and the other ingredients are satisfied. It is granted till disposal of the suit. But in case of an extremely urgent matter, an interim order is passed by this court. So is it a case of an extremely urgent matter? He himself has placed the right from 2022, this dispute is going on. Notices were served. So where is the urgency which comes within the ambit of Order 39, Rule 1 and 2? It could have been, if at all the suit is admitted, under Order 39, Rule 3, notice, hearing, then. Secondly, there was no threat from our side. No notice of eviction, termination has been issued, except that some notices of claim. And these claims are on the basis of a master circular which you have issued in terms of the agreement itself. Agreement says they have agreed that we can enhance. Therefore, there is no argument in advance on this issue at all. Thirdly, Miller, I have argued that when the Constitutional Court was approached on the self-same issue, and the Constitutional Court decided the particular 2 paragraphs of the master circular, the committee was constituted. The valuation report was asked for from the government of West Bengal. That is also in part of the 2003 and 4 contract. Valuation how is to be determined. No, these are not matters challenged in the suit. Therefore, where is the question of grant of injunction? And thirdly, there is no argument advance on forum shopping. Because on an identical issue, if a writ petition is moved and some orders are passed, whether doctrine of issue estoppel will apply in a subsequent suit or not. Then, my lord, fourthly, I have argued under Order 41, Rule 33, that if it appears to your lordship's power that this suit is misconceived, your lordships can dismiss the suit itself by exercising the power under Order 41, Rule 33. Because this is, even if no cross objection is filed, even if no cross appeal is filed, because the scope and ambit of I have given a judgment, and that has not all these judgments are not distinguished. Now, the question of the grant of injunction at a stage, I have shown to your lordship, I need not take lordship's time too much, that initially when the claim was made, I am just drawing your lordship's attention to the list of this I have already filed. Yes, this agreement is running from 23rd May 2023. Now the master circular came on 10th February 2005. There was a master circular. Then thereafter, the last master circular on the basis of which we have enhanced the claim license fee is the 4th October 2022. So 4th October to 2022, from 4th October 2022 to 26th June 2024 and 28th March 2024, there is no explanation in the injunction application. So where is the urgency for grant of an injunction under Order 39, Rule 1 and 2? Now, my lord, the argument which has been advanced that Order 41, Rule 11, 1998, Volume 1, Supreme Court cases, page 1, has categorically decided, that came from Rajasthan. One of our honorable judges was the Chief Justice at Rajasthan High Court, possibly lordships are aware. Rule of contempt was issued against the honorable Chief Justice. That matter went to Supreme Court. Supreme Court has categorically decided the determination power vested to the honorable judges by the honorable Chief Justice. Was Order 41, Rule 11 assigned to your lordship for admission of this appeal? If he accepts that Order 41, Rule 11, yes, applies, and it is deemed to be an order while your lordships are passing the order, that is given to a separate determination. Order 41, Rule 11. Therefore, it is not acceptable submission with great respect to him. The Order 41, Rule 11, the judgment of the special bench has also relied upon 2 other division bench judgments. The Order 41, Rule 11 has to be applied, even in case of there is a statutory appeal provides. In case of this particular case, the Commercial Courts Act, I have read and drawn your lordship's attention to Section 16. Not only Civil Procedure Code applies, but in case of any conflict with Civil Procedure Code shall prevail. Had it been a case that Civil Procedure Code has been excluded from the special statute, yes, statutory appeal could apply. Therefore, this is misconceived. The order is a nullity and it is to be dismissed, and suit is to be dismissed. Now, finally,
57 and contested.
now master circular has not been challenged. Admittedly, they have agreed. They have said it is not necessary. What they have challenged to notices issued under the master circular. If the circulars issued, I have already drawn your lordship's attention to Article 73. Executive power vests, and whatever orders, circulars are issued have a statutory force. There are several judgments I had the privilege to argue time and again on this issue. That has not been challenged. That was challenged before the Constitutional Court. So where is the cause of action subsisting thereafter on the same matter? Had it been a case they are challenging our decision of forming a committee, determining the valuation by a separate writ petition, then it could have been otherwise. How does the suit lie? Forum shopping, it is deprecated by the Supreme Court. Now, my lord, this actually conduct. About the conduct, I have given to your lordship the judgment of the Supreme Court. I have referred to specific relief act, section 41I. I have referred to specific relief act, alternative remedy. No injunction shall be issued. Now, conduct is they are enjoying a benefit since 2003. 7% enhancement is being made. They are paying. Now, from 2003 to 2022, they are enjoyed it. That we have exercised our power in terms of the agreement by enhancing the license fee, not rehearse the agreement or anything borrowed from outside or from the contract act. In exercise, they are stopped in law, raising that we cannot enhance the license fee. We have enhanced that. And therefore, my lord, in exercise of our power,
May I come back, my lord?
he wants me to continue for 5 minutes.
I was just inquiring, man. I was just inquiring. I will.
Yes, 5 minutes. 5 minutes is sufficient. Therefore, my lord, this 2022 to 2024 June, this period of 2 years, long 2 years gap, is it not the misconduct? Is it not the misconduct to approach the Constitutional Forum, having failed there to come back to the suit? Has there been anything bona fide on the part of the plaintiff? The case could have been otherwise.
Yes.
Now, my lord, the last payment made to us was on 13,83,641. That is for the period 21 to 22. Thereafter, not a single paisa has been paid to us. So, is it not coming within the ambit of Order 41, Rule 5, Sub Rule 3? Any money claimed, they are enjoying the benefit without extension of license, they are continuing their business without paying us. So, where is the conduct? Is it bona fide?
No payment after?
No payment after 28 June 2021. We have given to your lawsuit the list of dates, details. Point number 8. That was the last payment. And today we are in 2025. They are merely going on with the business. It's a huge project of the government of India. And when an interpretation is made on Order 41, Rule 5, Sub Rule 3, even in case of an execution categorically falls under Order 21 to 26. stay of execution when an execution case is filed, order 21 rule 26. But order 41 rule 5 sub rule 3 has a wider aspect. Whenever any order or decree is passed, deposit has to be made. So we are claiming 47,32,812 as NS license fee up to 28 March 2024. That has not been paid. And thereafter other demand notices were issued on 20th June 2024, 2nd May 2024. They objected to. Therefore, my lord, your lordships will kindly consider this aspect. The definition of conduct, the dictionary meaning also, does not help the plaintiff appellant at all. On the circumstances, on presumption.
Yes.
Now, on page 39, I have drawn your lordship's attention. Clause 14, the initial license and agreement. The license fee now fixed is provisional and may be revised upward at any time at the option of the railway, which licensee hereby agrees to accept. License fee will be revised time to time as per railway board's instructions. The master circular is issued by the railway board. They are stopped again in law from claiming that we are not obliged to pay the enhanced license fee. Stopped in law, stopped in fact, stopped in conduct, because I was hammering on this issue that the Supreme Court, apart from the question of prima facie case, balance of convenience and inconvenience, irreparable loss and injury, has inserted the question of conduct for refusal of injunction. Now in 2024, in another case, 3 honorable judges have included.
Mr. Chakraborty, it's an equitable relief injunction. Conduct always was important.
Yes.
Not because of any particular decision.
Yes, that's true.
Always.
That's true. But in the latest judgment of the Supreme Court, there are so many questions came up. I did not cite it with me. There the question not only of prima facie case and all, irreparable loss and injury and the balance of convenience and the conduct. The question of maintainability, prima facie has to be ascertained before granting injunction and going in for trial.
Justice Dotto?
Yes, Justice Dotto's judgment. Earlier, the question was whenever there is threatened injury, court was permitted to grant injunction. That has been changed, completely changed nowadays. Right from the Chadda's case and Delhi Municipal Corporation's case. Now, finally, I am drawing your lordship's attention to some paragraphs of 1993, Volume 3 SCC, the interpretation of Order 13 Rule 1 and 2, and distinction between Order 13 Rule 1 and 2 and Order 13 Rule 3. But I am reading the first para 35 of this judgment. I have handed over to your lordship judge, copy of the judgment. Para 35 has been gone down. As such, whenever a court considers it necessary in the facts and circumstances of a particular case to pass an order of injunction without notice to other side, kindly mark it, it must record the reasons for doing so and should take into consideration while passing an order of injunction all relevant factors, including as to how the object of granting injunction itself shall be defeated if an ex parte order is not passed. But any such ex parte order should be in force up to a particular date before which the plaintiff should be required to serve the notice on the defendant concerned. In the Supreme Court practice such and such, it is not relevant. Now kindly come to para 30. It need not be said that primary object of filing a suit challenging the validity of the order of demolition is to restrain such demolition with intervention of the court. In such a suit, the plaintiff is more interested in getting an order of interim injunction. It has been pointed out repeatedly that a party is not entitled to an order of injunction as a matter of right of course. grant of injunction within the discretion of the court, and such discretion is to be exercised in favor of the plaintiff only it is proved to the satisfaction of the court that unless the defendant is restrained by an order of injunction, an irreparable loss or damage will be caused to the plaintiff during the pendency of the suit. So where is the threatened injury? Where is the apprehension? No notice, nothing. Simpliciter, after having failed in the writ court, suit has been filed. There is no ingredients of a grant of an injunction either under Order 13 Rule 1 and 2. It was, if the suit was at all maintainable, this should have been a notice under Order 13 and Rule 3, ask for written objection, which the learned judge has done, and to decide it on issue. Therefore, this judgment categorically deals with the distinctive part between Order 13 and Rule 1 and 2 and Order 13 and Rule 3. There are 31, 32, 33, and 34. My lord, I am not taking lots of time. These are dealing with in detail the grant of injunction and the distinction between Order 13 Rule 1, 2 and Order 13 Rule 3. The Order 13 Rule 1 and 2, the language coached, is not being satisfied in the instant case at all. There is no threatened injury at all. Now, finally, my lord, no argument has been advanced about Order 41 Rule 33. I am again repeating that the question of dispensing with pre-suit mediation, which is required under the Commercial Courts Act, which is provided in Section 12, capital A, was not considered by the learned judge while dispensing with the requirement. Therefore, your lordships, in such a situation, it's a given situation of the long delay, no urgency, nothing to dispense with. And therefore, I am invoking your lordship jurisdiction to dismiss the suit by exercising the power under Order 41 Rule 33, which I have handed over to your lordship the judge. These are my submissions.
Only one point. My lord, if I know it correctly, my lord, only this court has the jurisdiction, my lord, under commercial division. This bench. So, my lord, question of my lord without jurisdiction, my lord, the order being without jurisdiction does not arise. It's a commercial division matter. No other court, no other division bench is entitled to take up, my lord, commercial division matters. The first point, which was again taken today. So, these,
if we understood correctly, is that if it is accepted that admission under Order 41, Rule 11 is required, whether it be a statutory appeal or not, then this court did not have the or does not have the determination to rectify the defect and say that, okay, we are now formally admitting. And an order without determination is a nullity. This is also what Mr. Chakravarti, if we try to do that today, if we hold firstly that it requires admission under 41 Rule 11.
Not that, my lord, your lordship cannot grant, my lord, leave under order, or my lord, admit the appeal under Order 41 Rule 11. No, that was not argued.
This is what we understood, Mr. Mitro. I can ask your learned friend, because he said that another bench has that determination.
No, that is exactly what I am saying. No other bench has that determination. Commercial matter, that bench does not have determination. Commercial division matters, my lord, only this bench has determination. This I, my lord, submit with responsibility. And so far as Shivkumar Chadda is concerned, my lord, kindly consider paragraph. We have all along, my lord, cited that, my lord, in paragraph 35 also says that ex parte interim order. I was not seeking any ex parte interim order. I was told to serve. Yes, I served. And then, my lord, a long date was given.
Hearing is concluded. Judgment is reserved.
Oh, and I have made payments
for 2023.
Till 22-23, I have made. Sorry.
in the course of hearing. Order করে নাও।
While the hearing had progressed,
See, one thing the first day when the suit was filed and injunction application was moved under Order 13/2002 was an attempt to move an ex parte injunction order. Yes, kindly see the orders appealed against. The learned judge placed it after 4 days, directed notice to be served upon us.
That we have noted. That we
Yes.
have noted.
Yes, I have accepted that. No, with greatest of respect, my submission is on the second day, the learned court ought to have passed the order. Instead of, my lord, sending it after, my lord, sometimes in June or July.
6 June, very well, yes.
And payment was it made?
Payment 109,110, kindly look into, my lord. I have made payment till 2022-23. Thereafter, my lord, no payment was accepted. That is my case. Page 109 and 110.
But Mr. Chakraborty says after 28th of June 21, there was no.
Kindly their receipt. 109.
Lord, I have submitted 7th November 2022 and 24th April 2023 list of dates. Lordship should kindly find that demand draft of 13,83,000 something was tendered, and what is the outstanding due? I have given in para 12 47,32,000 something.
Paragraph 12 of
List of dates.
list of dates cannot have any paragraph, with greatest of respect.
Yes, it has.
All right, we'll consider all this. We'll consider.
We have learned that.
We'll consider.
We did not.
May not. Doesn't matter.
It does, of course, does.
after the hearing had progressed at some length, while wading through the papers, it appeared to us that one of us, within brackets my name, had an occasion to appear against the father of the deponent of the affidavit to the stay application in a wholly unconnected matter prior to his elevation to the bench. Full stop. Attention of the parties was drawn to this fact, to which the parties submitted that they have no objection if this bench hears the present appeal. Full stop. Accordingly,
we proceeded with the hearing. Stop. Hearing is concluded. Judgment is reserved. হ্যাঁ ফাইলটা এখন খারাপ আমারটা আমার কাছে ওনারটা ওনার হয়তো থাকবে ও থাকবে
একটাই ফাইল নিয়ে যাব
ওরা তো পাঠিয়ে দেবে অর্ডারটা করেছিল লাস্ট অর্ডারটা হ্যাঁ
লাস্ট অর্ডারটা দেখে
আছে ফটো শিটের সঙ্গে ফাইল Thank you. What is the insistence?
On commercial property.
Five, 40. 45, 46. Non-commercial. Original side non-commercial item number 45 and 46.
My lord, I'm appearing for the respondent in this matter. My lord, Mr. Rajesh Dotto was appearing for the appellant, my lord. Appeal has been filed challenging the mean profit decree, my lord.
Let it stand over till after the vacation.
He was here. The doctor was here.
Anyway, 3:30 we have fixed a matter, we are told. কোথাও খুঁজে পাচ্ছি না তো fixed matter-টা। 3:30 টা কোথায় লেখা আছে? কত নম্বর? হ্যাঁ, হ্যাঁ। হুম, ঠিক আছে। The appellant is not represented. Stop. Considering that today is the penultimate day before the summer vacation, let this matter stand over till after the summer vacation and be listed on June 9, 2025. Let these matters go to appeal. 45-46 action করবে।
Personal matter item number 43.
Item number 43, my lord. I am appearing on behalf of the appellant, my lord, and I am led by my senior, my lord, Mr. Shami Mehmet. My lord, paper books, my lord, were filed, my lord, and after, my lord, filing of paper books, my lord, respondents, my lord, have indicated, my lord, 1 or 2 documents which we have missed, my lord, in our paper book. So today, my lord, we have obtained from the, my lord, our client, my lord, and my lord, we are only paying these, my lord, to file, my lord, a supplementary, my lord, paper books, my lord. These are the only 2 documents which we had missed, my lord.
On the request made by learned advocate for the appellant, leave is granted to the appellant to file a supplementary paper book incorporating certain documents which the appellant says came to his notice after filing of the paper book.
That was indicated by the respondents.
Let such a supplementary paper book be filed within 1 week after the summer vacation.
Yes,
Date দিয়ে দাও, June 16. So paragraph, list the matter immediately after that.
Contempt matter item number 48.
Contempt.
Lordship, I am for the petitioner, my lord. This is the Braille matter. Lordship, kindly remember that Braille matter. There was a certain mandatory direction, my lord, upon the Secretary Health Department. Personal.
Mr. Dotto, you better come to court physically and do the matter after vacation.
Lordship.
After vacation.
My lord, may I just, my lord, may I have your lordship's kind consideration to see the last paragraph once, my lord?
Last paragraph of what?
Of the last order. Last order. Kindly see once. Kindly see the conduct of the alleged contender once. There was a mandatory direction, my lord, dated 19th August 2020.
Whatever it be, unless you come before us, nothing will happen. Next.
Item
49. Item number 50. Item number 50.
দাঁড়াও 50 আছেন।
Sir, the replies have been served, sir.
Reply.
Yes, sir.
Which is reply?
So the opposite had replied to me, sir, and I had replied back to them.
You have given them copies?
Yes, sir. They have been given the copies, sir.
Very well. We will take your reply on record.
Yes, sir.
And tomorrow being the last day, we'll post it after the vacation, immediately after the vacation.
Sir, the one more, now 23, 24, sir, I have reported that they have done the contempt, sir, with your leave. Now, and now the 2025, sir. Now again, they are not given any advertisement, nothing. They are going their own street way, sir.
Very well. Do this. Lekho. Affidavit in reply filed in court today by the petitioner who appears in person, be kept with the records. paragraph. List this matter once again on June 20. June 13 করে দাও, June 13. Paragraph. Since the respondents are not represented today, comma, you are aware who the learned advocates are for the respondents?
Yes, sir.
Aware. Kindly serve a notice. The petitioner shall communicate this order to the learned advocate for the respondents. You appear for whom?
Not for the municipality, except the municipality.
13 June, come back ready. Come back 13 June করে দিও. Oh.
Sir, just if I want to, if you
Yes.
allow me, sir, now this on the 6th or 7th, this is coming, sir. So if you kindly just ask them to release the ads and everything, because they've done nothing, sir. That's a
No,
point,
we
sir.
have filed a complaints report, my lord.
They are saying they have done it, sir. Let us see.
For the 25th, for the 2025, I'm not, we have filed a report and everything for 2023 and 24. That is, we have taken. But sir,
Do the
25,
needful. Otherwise, you know what will happen. Otherwise, free accommodation for some time. State guest. So please instruct your clients, advise them to comply with the order. That's all.
yes, sir.
Come back.
Thank you, sir.
Item number 51.
Next.
Item number 52.
Next.
Personal matter, item number 48.
এই 48 তো হয়ে গেল after vacation. কি আশ্চর্য।
49.
Usual order.
51.
Usual order.
52.
Usual order.
For the corporation, there's a pending appeal before the SLP pending before the Supreme Court.
We don't know. The applicant is not here. Give your appearance. এবার কি ডাকবে ডাকো। এটা না দেখে 330 যদি অ্যাডভোকেটরা থাকে 330 fixed matter are learned advocates here for both sides.
Yeah, for the respondents, Mr. Mithra and I took two sets of respondents. I was appealing for the appellant. My lord would recall I had mentioned the matter day before yesterday. And Mr. Rutuman Bhattacharya and Mr. Ranjan Bachcha, senior advocates, were meeting us. And they are in some difficulty today.
They are not in court.
They are not.
Oh, তা হবে না আর কি হবে? You are for whom, Mr. Mitra?
Because the respondent number 1 and for the respondent number 2.
No, they had mentioned it yesterday, I think. Yes.
Then keep it after the vacation.
Yes, yes.
After 11 weeks. After I was informed, my lord, Mr. Basavath is returning on 14th. 14th, my lord, being a Saturday, my lord, it can be kept on 16th itself, my lord.
16th.
Will it be my lord's pleasure to retain the time also? I give it to my lord.
16th কি কিছু টাইম করা আছে দেখো তো।
Or my lord, prior to 3:30 because
3:30 কিছু আছে কিনা 16th? নেই, তাহলে লেখো ওই 3:30 ফিক্স ম্যাটার যেটা আছে। কত নম্বর আইটেম জানি না আমি। হ্যাঁ, কত নম্বর একটু আগে দেখলাম তো। কমার্শিয়াল। On the request made on behalf of the appellant, let this matter stand adjourned and be listed again on June 16, 2025, marked 3:30 p.m.
Commercial matter, item number 1. Item number 2.
Your Lordship, this is my application, my lord. This is an application taken out for restoration of the appeal, my lord. On 8th, my lord, this appeal was
8th of May.
8th of May, my lord. It was.
Oh, এটা দাও আছে অ্যাপ্লিকেশনটা?
May I file my affidavit of service?
Go to please. Go to please. Correction এ কিছু নেই বললো না
এটা নেই? ঠিক আছে। Now the reason for dismissal, it is at paragraph 42 at page 11 of my application, my lord.
Teju,
Kindly do not record my content.
shall we record your opposition? What does your client do? What kind of business?
My lord, it is a partnership firm who does contractual jobs for the Union of India.
Oh, it's profitable job, profitable.
My lord,
No,
very
some
little.
pay some cost to the state legal service authority.
My lord, already, my lord, the tax that is not reimbursed by the state till date and by the
This-
union, my lord.
This is an application for restoration of
Right, it is
AO-COM
absolutely my fault that
number 5 of 2025, which was dismissed for default on May 8, 2025. Stop. Paragraph. Learned advocate for the respondent opposes the application. Stop. Paragraph. Although we are not fully satisfied with the explanation furnished for absence of learned advocate for the appellant on the day the matter was dismissed for default, comma, they have been able to afford Mr. Basu.
No.
Yes,
I
I only
have come,
requested him.
only to give support to the junior.
The appeal, who will argue?
Yeah, appeal I will argue, but for the
Yes.
restoration, I have come
You
just
will
to
not?
give support. No.
The matter was dismissed for default, comma, yet, comma, for the yet, comma, taking a lenient view and for the ends of justice, we recall the order dated May 8, 2025, comma, subject to payment of costs assessed at rupees 3,000 to the state legal service authority within 1 week after the summer vacation. Date ta diye debe, June 16. Paragraph. Accordingly, AO-COM 5 of 2025 is restored to its original file and number. Next, GA such and such is disposed of. Next, list the appeal under the appropriate heading on June 18.
I do not admit the allegation.
Paragraph. Since we have not called for affidavits, comma, the allegations made in the present application are deemed not to be admitted by the respondent.
That may be on the 23rd.
Yes, 23rd.
Item number 3.
It's a appeal from an order by which my suit has been dismissed on the ground that there was no sufficient pleading regarding the dispensation of section 12A leave, and my interim order which I was enjoying right from the filing of the suit up till 30th of that month, 30th of April, was also not extended, and the
how will the order be extended if the suit is dismissed?
But dismissal, the hearing or last hearing happened, prior to the last date of the interim order, 22nd of April. Thereafter, for that entire month,
we mentioned twice, the order was not extended. And that ultimately on 6th of May, this suit was dismissed. So interim order expired on 30th of April, was not extended, and this suit was dismissed by order dated 6th of May. We tried mentioning twice. The Honorable Single Judge said that he was not inclined to extend the interim order because he was already deciding the issue of dismissal. And accordingly, this ultimately the suit was dismissed. This is the order impugned. Now, my lord, the primary point that I had taken is that there is no case of suppression made out in the application for revocation of that leave. There was no, my lord, falsehood in the pleading. Only thing is that when I got to know about the infringement, act of infringement in January, why did I file the suit in August? The intermediate period of 7 months, there was an explanation regarding that, or what did I do during those 7 months, and that is the basis of the order. Because of the absence of pleadings regarding those 7 months, the suit was dismissed. Although, my lord, upon showing those very pleadings, I had obtained the very leave of 12A from the coordinate bench at the time of filing of
All
this suit.
papers are before us.
All papers regarding the dismissal order are before.
We hear out the appeal. Suit has been dismissed. Appeal has to be heard out.
Yes, but I have an interim prayer for the restoration of the injunction which I was enjoying all throughout from the.
We can't. We have to hear you on that.
Yes.
Proceed. Proceed.
Yes,
Without hearing you, how can we?
Only, that is
We have to stay the operation.
Time
Then
is by Mr. Kushal.
you want to.
I thought I'll go home.
So open the appeal. What can be done? Your junior says he immediately wants the interim order to be restored.
Immediately, no? I said there is a prayer.
This
We are prepared to hear you till 4:25.
I would be, I mean, they can start the matter, Your Lordship. I'll take the notes. My only request is, Your Lordship, that since I'm being led by Mr. Shomura Chaudhary is on his way, let them finish the arguments. We can come back tomorrow and reply.
Tomorrow?
For replying. Or if Your Lordship pleases, I can
Take
start replying.
take a decision. If it can wait till immediately after vacation,
Put it on 10th. My lord, I come back, my lord.
we'll keep it on 10th. No problem at all.
If you
One thing I must point out, my lord. In this matter, my lord, there was some, my lord. I argued, I was on the firing line. One memo of appeal is ground number 34, which 33, which I feel I shouldn't press. Ground number 33, Lordship permits me to, my lord, delete it. Expand. Yes, there is a human, my lord. It happens sometimes in the bench. There is pressure. Sometimes I, my lord, cannot, my lord. It may be, my lord. It
May
may
I-
be apparent from the
Delete it. Delete it.
Yeah, Your Lordship, kindly don't accept this kind of prayer because Your Lordship, when
I
a
don't
draft,
have to press that prayer.
kindly, what
Very well,
my
then, my lord.
request is, Your Lordship, when an appeal is filed, it goes through multiple levels of draftings. It has been
I
consciously
have
being
not
put,
said it. I have not said
and
it.
therefore, Your Lordship, kindly don't
I
accept.
do not want, my
In
lord.
fact,
We
Your
have grown
Lordship,
up together.
If
There
both
was
of you
lot of
speak
fact.
together, we don't follow
that is the
anything.
thing, Your Lordship. I started my argument. I didn't interrupt.
What are you saying?
What I'm trying to emphasize is, Your Lordship, this has gone through multiple levels of scrutiny and settling. This has been a conscious decision on the part of the appellant to include these grounds. Kindly don't allow the prior expungement. Instead, Your Lordship, kindly come to ground number 5.
We will ourselves expunge this ground.
Your Lordship, kindly come to ground number 5.
I leave it to your lordship, then lordship looks at the order. I felt, my lord, as
Anyway,
a
Your
senior
Lordship, the
counsel, I
language,
should not, my lord, press this, my lord, because it's, my lord, doesn't. It may sometimes happen, my lord, we are on the firing line.
Anyway, since we are not hearing the appeal today,
Yes.
this appeal is directed against a judgment and order dated May 6, 2025, whereby the appellant's suit stands dismissed, was dismissed
On dismissed on the ground
upon revocation.
of 12.
Upon revocation of leave that had been earlier granted under Section 12 capital A of the Commercial Codes Act. Stop. Learned senior advocate for the appellant says that
I don't want to press ground number
all papers
33.
are before us
33 and 34, I don't want to press.
as annexures to the stay petition, and the appeal can be heard out immediately after the vacation. Stop. Paragraph. Learned Senior Counsel further says that he is not pressing ground number.
Rounds 33 and 34.
Ground numbers 33 and 34, Roman 33 and Roman 34. As enumerated in the memorandum of appeal. So we will consider that issue on the next date. Paragraph. List the matter on June 10, 2025.
Paragraph of this state.
Under the appropriate heading. Now, under the heading appeal from orders. Amongst the first 5 items.
10th June.
First 10 items.
No, 10th June, 9th.
10th June we have said amongst the first 5 items.
I leave it to you, Lord.
আচ্ছা 10 বলছি 10 করে দাও তাহলে amongst the first 5 items when we propose to hear out the appeal treating the stay petition as an informal paper book.
Milord, also, Milord, paragraphs 38 and 39 of this stay application. I don't know.
He
Those are
does not
repetition, I don't
will does not press na কি বলেছে ওখানে as well as paragraphs
38 and 39
38
of
and 39 of the stay application.
Sometimes it happens, but it shouldn't. I told them, Milord, in the conference. Milord.
Your senior has disappeared.
Oh, Your Lordship is on his way from Alipur Commercial Court. Great.
Mr. Roy Choudhury.
Yes, yes. Mr. Shomar. Grateful.
Item number 4.
Lordship, in respect of item number 4, I appear on behalf of the appellant petitioner, my lord. I apologize at the instant, my lord. I am on virtual mode. Should have been present in the court, my lord. On the last occasion, there was a direction upon us to serve a copy upon the official liquidator, my lord, which we have done. And the official liquidator has submitted a report, a copy of which has been given to
Official
us.
liquidator of this court or of that?
No, my lord, the official liquidator of the Madhya Pradesh High
Madhya
Court, if
Pradesh
your lordship recollect.
Very well, you come back after you come physically. Let us have the honor and pleasure of seeing you in person.
Definitely.
One small prayer, if the report can be given to us as well, my lord.
Where is the
My lord, I'll serve a copy upon my learned friends. I'll serve a copy upon my learned friends. Possibly the official liquidator has not given a copy. I'll take it upon myself to serve it upon my learned friends.
To whom has he sent the report? To you?
My lord, the report has been sent to the registry with a copy marked to us, my lord.
Dekho. Very well. He will give it to you, he said. Dekho. Learned advocate for the appellant. He is for the appellant.
Yes.
Says
Yes,
that pursuant to our earlier direction, comma, the official liquidator attached to the Madhya Pradesh High Court has filed a report. Stop. এই তোমার ফাইলের রিপোর্ট আছে? Stop. He says that he will make a copy of the report available to learned advocate on record for the respondents. Stop. Let that be done before the next date. আছে তো? ঠিক আছে। রেখে দাও। Paragraph. List this matter once again on June 10. When will you come back from?
Week later, my lord, because we
When will you come back from holiday?
My lord, I'm very much here, lordship.
You're very much here.
My lord, I'm insisting on after a week because, my lord, then we will get some time.
June
to review
16.
the report. Grateful.
June 16.
Grateful, my lord. Grateful.
Item number 5 and 6.
ওই একটা জায়গায় add করে দাও তো, we also see from our records that such a report has indeed been filed. রেকর্ড করে রাখা ভালো, যে রেকর্ডে আছে আমাদের। ওই প্যারাগ্রাফই ঢুকিয়ে দেবে, হ্যাঁ, যেখানটা লিখেছো। হ্যাঁ হ্যাঁ।
Item number 5 and 6.
My lord, I am for the respondent. My lord, I am appearing for the petitioner, Mr. Subroto Datto, arguing in this matter. In this time, Mr. Subroto Datto engaging to the another court. I am paying for, not today. Please,
Not today.
Please fix a date.
Next Monday?
After vacation. My lord.
After vacation. Very well, after vacation. Accommodation is sought for on behalf of the appellant, on behalf of Messrs. Konarak Enterprise karo. Huh? Stop. As requested, comma. Let this matter stand adjourned. Let these matters, দুটো একসঙ্গে আছে বুঝছো? Stand adjourned and be listed on.
The affidavit of service.
Listed on June 11, 2025. Stop. Paragraph. Affidavit of service filed on behalf of Huldia Development Authority be kept with the records.
Also, my lord, my section 5 is there. My lord, lordship can dispose it of on the
How
day.
long? How much delay?
16 days, my lord.
16 days. Sir, have you served?
Yes.
I don't think. Are you briefed in the matter?
Yes.
Are you briefed in the matter? You're not briefed. Come back. We'll condone it. Not a problem.
Item number 7.
I'm grateful. Let's back.
Your Lordship, I am for the appellant petitioner. Last order was for direction affidavit in service. Today the affidavit in service is not ready. Kindly fix it after summer vacation.
Learned advocate for the appellant says that affidavit of service is not ready. Stop. As now she seeks accommodation. She seeks accommodation. Paragraph lists this matter once again on June 10, 2025.
Item number 8.
Ure Baba.
Opposing on behalf of us, this one.
May it please, Your Lordships, my lord, I'm appearing for the appellant.
Deeply does matter.
I'm not sure. I'll finish it.
I'll take 5 days. You've taken 3 days, I'll take it. But might as well, my lord, go after the vacation. my lord.
But I will.
Whatever you agree.
The only difficulty is my learned senior friend has just indicated that I'll take at least 5 days to reply.
Learned friend's taken, my lord, 3 days, yet not come to the order. So, my lord, I was thinking, my lord, that maybe I'll take, my lord, 5
I'll
days.
indicate my difficulty, my lord. I'll then come back after vacation if it so falls from your lordships. I'll indicate my difficulty.
Nothing will fall from us, Mr. Bagh. We are here to hear matters. Right?
I understand.
Just take a practical approach. Think about everybody. Tomorrow is the penultimate day. You have 45 minutes left today, of which you'll get 40 because we'll rise 5 minutes early. And tomorrow again, you know what happens on the last day. So we need not tell you. If you want to proceed, we'll be happy. We have no problem. You decide. Discuss with.
What do you want to do? But as it is, they will reply for 5 days. And wasting the honorable court's time. What do you want to do? Tell me. My lord, may I only pray for this? If we come back after the vacation, my lord, I understand what is falling from your lordship. It's a heavy matter, my lord. I need to make submissions. I need to show documents, my lord. My lord, may I only pray then kindly, if your lordship.
If it was not a heavy matter, would they have briefed you?
My lord, I'm humbled, but kindly do not embarrass me, my lord. My lord, may I only pray for this? My lord, may we come back on the 9th?
Yes, come back
And
on
my
the
lord,
9th.
Because
My
I'll
lord, kindly make it 17th, my lord. We are not.
my lord, this
9th, 17th hardly makes a difference. 17th.
my lord, I'll indicate what my predicament in the my lord, entire matter is. My lord, I'm praying for an ad interim order. My lord, until unless I make those submissions, I'll not be in a position to my lord, indicate why I'm praying for that ad interim order. My lord, in any other matter, I would not have made this submission.
My lord,
For dispersal of money. For dispersal of
For
money.
dispersal of fund for the treatment.
my lord,
Otherwise,
may
my
I
lord,
say this? My lord, I gave a threat of 5 days, but if it's on the 17th, my lord, I won't take more than half an hour.
And in any event, the improved order was passed in 9th April.
my lord, we have attempted, my lord. The only difficult
The 2 weeks time to prefer the appeal, which has been going on.
I'll also indicate
Interim order, whatever my learned friend describes it as, will dispose of the entire appeal.
Mr. Bose, Mr. Bagh has only said that he will pray for an interim order. He has not said it has to be allowed.
My lord, the only difficulty I'm facing is, my lord, it's a time constraint, my lord, for the appellant. My lord, that is the only difficulty because every day, my lord, he is incurring expenditure.
So how long will you take, Mr. Bagh?
I'll take, my lord, an hour. I'll keep it on the lesser side. I'll take 40 minutes. I'll complete my submissions in
এই
40
এই কোথায় গেল দেখো তো 17 জুন কি অবস্থা What day of the week is that?
Tuesday, my lord.
হবে 3:30 হবে 3:30
Right.
17
I do not know, my lord, the fate of the 3:30 in the
3:30 Tuesday, not a Friday.
Not sure. Because I'm indicating my difficulty, my lord. It's only because of this matter, my lord.
We are
because of the-
fixing it for you specially.
Not sure. We'll
That is
come back
why.
on the 17th.
Yes.
We'll do so.
লেখো Learned counsel for the parties, comma, in view of the fact that today is the penultimate day before the summer vacation and less than 40 minutes time is left, comma, jointly suggests that this matter may be listed on June 17, comma, 2025. Stop. Paragraph, list this matter once again on June 17, 2025, marked 3:30 p.m.
I'm deeply obliged, my lord.
Personal matter item number 1.
আছে ছিল না কেউ এই যে আছে
For the applicant, the service has been effected with to both the respondent. Here is the affidavit of service.
very well.
Lordship, I'm led by my counsel, Shohrojit Dasgupta, in this.
Who?
Shohrojit Dasgupta in this matter.
Yes.
Kindly, if your lordship may permit to keep this matter after vacation.
After vacation. Affidavit of service filed in court today. We kept with the records. Paragraph on the request made by, kindly give your name. A request made by learned advocate for the appellant, comma, list this matter once again immediately after the summer vacation.
Item number 9.
ওরে বাবা।
Item number 10.
এই 9 তো আছেন তো
My lord, I appear for the respondent, my lord. I apologize, my lord, for appearing.
Mr. Mitra is for the
My lord, award debtor appellant before.
Lord, I had commenced my submissions, but my lord, your lordship must have forgotten altogether.
flaring up.
Yes.
I'll have to start all over again whenever it's convenient to your lordship.
Why all over again, Mr. Mitra?
Not before the 18th. I shall come back on the 13th.
Oh, I see.
So 16th is the Monday. But we are still in.
We are taking notes. Don't worry.
No, I'm sure your lordship are taking notes, and I will have to refresh your lordship.
We remember 28.5% or something had to be flared up. This is the argument.
On which day will it be convenient for your lordship? If we know, my lord, I think I am perhaps I am not in a state of quandary to understand, my lord, exactly on which day commercial and on which day non-commercial will take.
Alternate.
No, alternate, my lord, unless we know, my lord, when commercial matter will be taken, which day commercial, we won't know which is the alternate day on which, my lord.
Start from day 1, Mr. Mitra.
Commercial.
For example, tomorrow is what? শোনো তুমি এত ঝামেলা হচ্ছে যখন তুমি একটা কাজ করো পারবে না তুমি করে দাও যেরকম করছিলে হ্যাঁ
on Monday commercial
Monday Wednesday Friday commercial first then non-commercial.
So my lord, in that event, my lord, can we have on the 18th is a commercial day?
We can.
My lord, kindly, my lord, keep it
on the request made by Mr. Mitro, learned senior advocate representing the appellant.
May I make a
not the appellant.
Is possible to have a time, my lord?
The first matter.
And my lord,
it will be the first matter.
And part heard. That's a joint request.
That's a joint. Please don't embarrass us, Mr. Mitro. No. JSOF we did, but not this one. Gulam? Learned senior advocate representing the appellant, let this matter stand adjourned and be listed again on June 18. তুমি ওই নোটটা দিয়ে দিও তাহলে আবার পাল্টে June 18 as the first item under the heading appeal from orders.
Grateful.
হ্যাঁ যে আগের ছিল যেটা এটা বড্ড গোলমাল হয়ে যাচ্ছে দেখছি
And your lordship's list will now henceforth will show that Monday, Wednesday, and Friday.
First
So that we
commercial.
know exactly on which day commercial and on which day the
Very well,
non-commercial.
very
It clear. Okay. Everybody, my lord, was in a state of quandary.
right.
We had been asking each other which day will be commercial and on which day will be non-commercial.
Some amount of uncertainty makes life exciting.
Yes, my lord, it is exciting. Absolutely. Only thing is, my lord, that one has to wait for the whole day.
No,
for the
we
purpose-
understand. No, now it's clear.
Now it's lordship.
Item number 10.
10, I appear for the appellant, my lord. This is section 37 appeal, my lord, arising of a dismissal of a section 34 application. But if my lord wants, I can start, my lord, or
We want nothing. What do you want? You tell us.
whatever, I leave it up to my lord. My lord will keep it that side of the vacation.
Tell us that why keeping the gun on our shoulders? On the request made by learned advocate for the appellant, comma, let this matter stand over till
My lord,
after the.
could I only pray for this? If it's a joint request, my client is a state of West Bengal Housing
Can it
Board.
be a joint request, sir?
Yes, sir.
Ah,
But last time they took on adjournment for last 2-3 times.
No.
3 times.
My lord, we kindly have the order. We've been present throughout.
Let this be the
Actually-
last time.
My lord, last few times we've been here.
On the joint request made by learned advocates for the parties, comma, let this matter stand over till immediately after the summer vacation.
Obliged. Deeply obliged.
No, no, last time, sir.
No. My lord, we've been
It is
here.
understood that on the adjourned date, the matter will definitely be. Lekho. Paragraph kore lekho. It is understood that on the adjourned date, the appellant shall positively open its case. Happy? Happy vacation.
Obliged. Obliged.
Item 11 and 12.
My lord, I am appearing for the respondent. My lord.
Yes. কোথায়? Why there, Mr. Roy?
My lord, because the other side is not there, my lord, that is why I was only.
Can't even hear you clearly.
But the other side is not there, my lord, that's why, my lord.
Oh, other side is not there.
My lord, Mr. Banerjee, I think he is not in India at the moment.
Oh, I see.
Shatru Banerjee, my lord, this is that matter, my lord, assignment of
Incorporation.
Incorporation, my lord, yes, your lordship.
After vacation, what to do? The appellant is not represented. দেখো, the appellant is not represented. 11-12 একসাথে করো. Paragraph as suggested by Mr. Ray, comma, learned senior counsel, appearing for the
respondent, my lord.
Respondent number 1, or both the respondents. Respondent number 1, comma, let this matter stand adjourned. What? Give us a date. When will Mr. Banerjee be available? I don't know. We don't know.
Well, then 23rd, my lord, 23rd.
23rd.
My lord.
We listed on January 23, January, June 23.
My lord, let's be making this from the morning, my lord, January. Not the weather for coming to a conclusion is January, my lord.
You better come physically on that date.
But I will, my lord. Today it was just an adjournment, my lord. That's right. Kindly does not take me amiss, my lord, because, my lord, only because, my lord, the matter is not going.
Item number 13.
My. Here comes. My brief was not come, is it? My brief has not come, is it?
Your brief has not come.
Okay, it's just come.
You take my brief.
No, I have. No, Delhi has not.
Mr. Laidi, you have barely half an hour. You'll keep us occupied?
I will.
You will?
I will.
Released.
बोलो ना, बोलो ना. क्यों बोल रहे हो?
Lordship, I am led by Mr. Abhishek going in the next matter. Next matter, item number 14.
Yes, you are, you will say?
Lordship, kindly allow us to come back after the vacation.
You are for the appellant?
Appellant.
14 এ একটা order করে নাও তো। On
Lord,
the
I appeal for the respondent in that matter, my lord. On item 14.
very well.
Volume 1 টা বার করবি তো?
On the request made by learned advocate for the appellants, comma, let this matter stand over till after the summer vacation.
I'm grateful. Anyone else to mention?
কৌশিক ওই যেগুলো আফটার দ্য বলছি
নামগুলো
কিছু বলছি না, 9তেই দিয়ে দেবে এগুলো। হ্যাঁ ব্যাস।
My bench on matter, if your lordship will permit me, item number 15 and 16, I'm sorry, my lord. I'll keep it in mind. Mouse by
এটাকে off করো।
for one of
Mr. Sharkar, matter can't be mentioned just like that.
I was going to the time.
Sure. Yes, Mr. Iri. Have you retrieved your brief?
Yes. This is because of that commercial, non-commercial, my lord, I can understand.
Right.
Now, my lord, on the last occasions, I have argued on the point of limitation, on the point of value of wagons, and on the point of, my lord, the freight rebate.
You'll conclude today, Mr. Iri.
Maybe. I'll try.
No, please try.
I'll try.
On a very serious note, please try.
I'll try. My lord, on my lord, the third, the award was passed, was based on loss of profit. Well, I started arguing on loss of profit, and I have stated that they had relied upon 2 agreements with Sesha Goa for 2 months, where the agreement doesn't provide that they can transport goods for third parties. Now, while going through the records, I have come up with this is a new argument before the section 37 court, but this is important, my lord. I would say the award is vitiated by fraud. This is a new point I'm taking up right now. Now, why I'm saying the award is vitiated by fraud is that, my lord, they had produced, the claimant respondent had produced certain bills with Sesha Goa, which are annexure LL at page 395 of volume 1 of the paper book of record, index of record of arbitration. LL volume 1 index page 395.
মোটা ভলিউম হাত মুচকে যাবে দুঃখে। Is that will we not find this in the convenience volume?
No, this we have not put in the convenience compilation. Page 395. 95.
Volume 1.
That is in print. There are 2 numbers, one is 395 and one is 272. For 395 onwards, till 409 of that volume are the bills which is purportedly issued to by electro-steel casting upon Sesha Goa.
Till 272, till 395.
395 till, my lord, the last page 409.
Yes.
But the reflections of the bills are annexure JJ at page 391, but I have put that in the convenience compilation. Now, my lord, I have found out that this is service rendered by this contract is a service rendered by purportedly by the claimant to Sesha. None of the bills have a service tax component. Because that 2009 there was no GST. There was no GST. GST came in 2017. But service tax regime was very much present at that point of time. And we are talking about two limited companies. Therefore, my lord, all these documents related to the agreements with Sesha Goa, on the basis of which the claimant had claimed loss of profit, all are fraudulent documents. And therefore, my lord, it is hit by, my lord, section 34. Thirty-four 2B, Roman 2, Roman 1, which says, if the court finds that the making of the award was induced or affected by fraud, corruption, or in violation of section 75. Because this is reflected, how I will say, kindly see the amount is 11,89,590, and the same amount will be reflected in annexure JJ, which is the bills I have annexed that in the convenience compilation. And based on that is annexure KK, on the basis of which award was passed. Well, I'm raising this point, but I'm putting them to notice. So I'm raising this point that this entire exercise of arriving at loss of profit, depending on two agreements with Sesha Goa and producing the bills before the tribunal, was completely overlooked by the tribunal while taking into consideration and passing the award on the entire loss of profit calculation as per annexure KK. Well, the next point in this is such loss of profit was not claimed either in the notice of termination or in the section 21 notice. Convenience compilation. Or the termination notice. ওই এগ্রিমেন্টটা দেওয়া ছিল ইয়ে এলো না অমৃতা ফোন কর But the termination notice is at convenience compilation page 32, dated June 17, 2016. They have claimed mean profit in paragraph 13. And then selling of wagons at 32 lakhs odd, 32 crores odd. In paragraph 14. And then they just say we are terminating your agreement. And minus this mean profit, what they have claimed is at page 130 or page 41, which is annexure B. But this is exact replica of the loss of freight rebate, which is annexure FF, which is at 118. But just one figure, if I show, my lord, will find out. The first figure says 932,723.81. 0.81 or 0.01, and page 118, which is annexure FF, the first figure is the same. So no claim on account of loss of profit has been made in the termination notice. But the next document is the section 21 notice, which is dated 3rd October 2016, where also, my lord, there's a good type copy, my lord. Kindly takes page 48, which is 135A. Nine, we terminated the agreement dated 9 January 2008 by our letter dated so-and-so. Since railways have been using our wagons and carrying freight, we are entitled to claim mean profit of 24, same as before, and sell wagons at 32.16, which is paragraph 11. Then till date, 13, till date, there has been no reply to our aforesaid letter of termination. Then modifications of WS policies are not allowed to use the rakes as per agreement. Alteration of WS policies without jurisdiction. You have failed and neglected to allot guaranteed amount of rakes for preferential order without assigning reason. Next 17 is at next page 50. In this circumstance, disputes and differences have arisen between the parties and law concerning the agreement, and therefore call upon the nominate the arbitrator. So this loss of profit, which they have claimed in their statement of claim, by using those two agreements and those bills, do not feature in the termination letter or in the section 21 notice, which has been completely overlooked by the tribunal and by the section 34 court. Now, I would also add one point into the value of rakes, my lord, because the agreement does not provide what will be the buyback of the wagons. But I will provide the agreement copy, my lord. It was already typed. I think Ms. Pandey is not here, so I will hand over to you, my lords. The agreement was sort of little eligible. I will hand over the copies. Now, my lord, buying back of wagons, the expert had relied upon Indian Railway Financial Code, clause 777. But Indian Railways Financial Code 777 relates to inter-railway transfer of assets. So that code says transfer of rolling stock from one railway to another. It does not contemplate buying back by the railways from the third parties. The calculation of depreciated value of the wagons taken as per Indian Railway Financial Code was completely out of the agreement. And my lord, even if the buying back of wagons were to be allowed, now, my lord, after the Supreme Court latest judgment, my lord can alter the award. My lord, previously it was you had to just set aside the award and remand it back, or not remand it back, set aside, and then the claimant would have taken. My lord, therefore, my lord, we had to buy back the wagons. The agreement says at a mutually agreed price. If there is no mutually agreed price, the basic, my lord, rule would have been under the Income Tax Act, the depreciation had to be calculated under the Income Tax Act. And on that basis of depreciation, whatever value was there, we had to buy back the wagons. 777 of the code of between the IRFC was not at all applicable, and that too, my lord, the application was for 40 years of the value of wagons, whereas the wagon was zero value at the hand of the claimants at the end of 10 years, because the agreement was for 10 years, and after 10 years, the wagons would have come into the general pool of the railways. So, on the first count of calculation on the value of the wagons, the arbitral tribunal completely mistook the agreement, went beyond the agreement to rely upon the the expert who has relied upon a different calculation of cost of wagons. Now, on freight rebate, I have tried to show, my lord, they had no freight. The agreement type copies have come. One of the copies. On my lord, freight rebate, I have tried to establish before this honorable court that they had no freight post 2010. Firstly, because there was this interstate transfer policy, which prevented transfer of iron ores or minerals from state of Odisha to state of Jharkhand. They, by their letter dated 2013, said that their mines at Jharkhand did not produce enough ores. So, to claim freight rebate, when they could not load any goods under the scheme, they had other goods at other stations, would not entail them at any money on, my lord, the freight rebate. And I have, my lord, tried to show today that the claim of loss of profit, firstly, is based on fraud, and secondly, my lord, based on two agreements, where the agreement said a loading point and unloading point is from one station to their own factory. They could not have used such goods or such freight for third parties. So, on these three counts, my lord, the three heads, the arbitral tribunal completely failed and passed the award. Now, regarding the counterclaim of the respondents, but regarding the counterclaim of the respondent had claimed loss of freight. And on the basis of loss of freight, what we did was, what was exhibited was a chart which we provided, that month-wise chart we provided. But a tribunal believes in a month-wise chart filed by the claimants as annexure KK and annexure JJ. No, not KK. KK and the other one. But does not believe our chart. We had said that this much, if you would have loaded 6 rakes per month, we would have got this much freight, out of which you could have got freight rebate. Since you have not loaded, we have lost on freight. The learned tribunal, what they did was, they said you have not produced any evidence as to the chart. When the rakes are determined, when the freight is determined, how much load to be given in the rake, that is determined, then we have to only produce the details of the calculation. Because on the basis of a calculation, if we could have got the freight, they would have got the freight rebate. So their chart of freight rebate becomes sacrosanct, and our chart for claim of freight becomes without evidence. But on this score, the tribunal completely failed and neglected to grant us our counterclaim on claim of freight charges. And they have not ever argued that this is barred by limitation or something like that. Our claim was barred by limitation, was never argued. And in the cross-examination,
Yes.
in the cross-examination, we have stated that the railways have suffered sizable amount of revenue loss for not receiving the indents as per the WA scheme. That I have indicated the question numbers in my notes. Now, the next point, which is also very important, is that the award goes on to deal with the construction of the private siding. A sizable amount of the award is on the base of the construction of the private siding. As I have indicated that the agreement between the parties, clause 10.2, clearly stated at page 5, my lord, here. I have given the typed copy, my lord. If the investor company requires own private siding, it will be governed by the relevant siding agreement in respect of infrastructure facilities, including maintenance of the wagons within the siding premises. So the construction of the private siding was governed by a different agreement than this agreement, which contained the arbitration clause. So my argument in this is that the award violates section 34 2A4 Roman 4, which says the arbitral award deals with a dispute not contemplated or not falling within the terms of the submission to arbitration or contains decision matters beyond the scope of the submissions of arbitration. Well, this was argued before the 34 court, and my 34 court had negated my point also. Now, on this point, my lord,
yes, we have to rise, Mr. Lahiri.
It will come back on 9th. Come back on 9th.
Mr. Mukherjee is not there till the so after that.
I'll come back and finish.
Mr. Lahiri, learned advocate appearing for the appellant, resumes his argument but does not conclude. Paragraph lists the matter after the summer vacation on June 17. এটা কি এটা কমার্শিয়াল তো অরিজিনাল হ্যাঁ তাহলে 17 হবে না, 18 হবে। বুধবার, June 18. June 18. এটা না।
Judge